Each under the learned funds preparing for the user submits that he has instructions for documents bail application. Prayer is allowed. Instant bail application is dismissed as withdrawn.
Deep Lordship. May I please, your Lordship? Which is back to my item number 48, Lordship. 48, Lordship.
Yes.
Lordship, this matter may be adjourned for the day, Lordship. And if this is on next week, any day, Lordship.
Doctor of
B. Borgo, Lordship.
B. Borgo and learned funds. Mistake after
Can be on,
a week.
can be on 18. No interim was there, Lordship.
Will it matter of this
18. Mass of Lordship.
My lord, I beg to mention for item number 40, my lord, may kindly take it on 22, my lord, 22-6.
on the prayer of SD Chaudhary. So the force is the method 22nd.
Oh, blessed, my lord.
The FIR is at page 11A, my lord. Petitioner is the, my lord, father-in-law of the main accused, my lord. He is behind the bar for 19 days, my lord. Plus, we'll find the FIR at page 11A, my lord.
So we'll call for the
But my lord, the petitioner is the father-in-law. He is no way connected with this incident, my lord. He lives at Gauhati, my lord. He's a tailor by profession, my lord. And this is something about his son-in-law. I admit that he may have done something, my lord, son-in-law. But he is no way connected. Only because he could not be arrested, police caught him, my lord. And he's put behind the bar for last 19 days. He's behind the bar. His statements have been recorded, my lord. He is no way, everything has been seized. All computer, all the incriminating documents have been seized already, my lord. So there is no question of destroying any evidence also, my lord. So he is no way connected, my lord. He's only because of his father-in-law, my lord, he has been arrested, my lord. He's put behind the bar, my lord. These grounds are not at all applicable to him, my lord. They are just general grounds. They put all these grounds, my lord, to justify their arrest only, my lord. Because already statements have been recorded, my lord. So further detention, in my humble submission, my lord, is not warranted, my lord. Already 19 days he's behind. 2 days police custody. Thereafter he was put to judicial custody, my lord.
What does he do?
My lord.
What does he do? This person?
Tailor, my lord. He's a tailor. Tailor shop is at Dhirenpara, Gauhati, my lord. The incident is at Thuburi, my lord.
Lordship, kindly come to page 30, round number 3, Lordship. So entire Lordship, monetary transaction of the prime accused, that is Zahidul Hussein's, he has maintained the entire monetary transaction, Lordship.
Their statement, my lord.
So CD will reveal everything. Let us call for the case study. It's from Dhubri, Lordship.
19 days, where he's an innocent person, my lord. Without any reason, he is put behind the bar, my lord.
Lordship.
And he is not named in the FIR also, my lord. Named one person has been arrested. His son-in-law could not be arrested, my lord. No way connected with this
Without
incident.
going through the case study, we cannot say anything, Lordship. If he's innocent, Lordship, CD will reveal.
You will have to stay for more days now.
Short date may be given, Lordship.
the only thing.
Produce a case study.
So we'll give a short date.
Yes, Lordship.
We'll see what is there. If it's
Yes.
nothing is there, it's already. As Mr. Arrest.
But it is the 19, my lord. Because another case, my lord, fixed on 19, my lord.
Similar cases are there.
On this FIR, my lord.
Same affair. 19.
Yes, no, 19, my lord.
So we'll fix it on 19.
Lordship.
Application. And is an application or a second court of BNS. Praying for grant of bail to the accused in connection with UB PS case 14226 under section 61 bracket 4 stroke 148 stroke 314 stroke 316 stroke 56 stroke 35 stroke 5 of BNS 023. All for the city. Let the matter.
On 19, but along with AB number 118626.
The matter will listed along with the AB number.
AB number 118626.
Okay.
Apply.
1
May it please your lordship. The FIR is at page 20. We are the employees of the water treatment plant at Satpukri. Three employees, Satpukri, this is in top of that Navagrah hill.
Okay.
But we are three employees were walking on that on the evening of the particular day of the incident. And one of the employee fell from the top floor when he went to open the valve and he died. Now, brother-in-law, this informant has lost this FIR saying that some unknown person may have assaulted him. That is at page 20. Then we were arrested. Then your lordship will see the forwarding report, the grounds of arrest. Your lordship will find the grounds of arrest at page 28. 28. This is an AI generated grounds of arrest. And my lord, your lordship will see they have quoted all the Supreme Court judgment on last opportunity, page 28, the grounds of arrest. You tell us the evidence, then you'll also see to extract forcefully a confession. They were tortured in custody. You'll also will see the observation of the learned magistrate at page 41. All the judgments, I have never seen a forwarding report like this where now the judgments are quoted on the ratio of the law laid down by the Supreme Court. Page 41, you'll also will see the last paragraph. They were so brutally tortured, even the learned magistrate thought that it is not proper to grant them further police custody. And my lord, the police station is just Lotasil police station, my lord. I pray, my lord, that your lordship will looking into the circumstances and the torture in custody. I pray that your lordship will kindly take up this matter on Monday next, my lord, because this person's unnecessarily, it is an accidental death. Your lordship will, just because there are three persons were there, nobody could enter. In a secure premise, my lord, if a person dies with accident, how can you arrest the other two persons? And these are the persons who have given the information to the police that one of our colleagues had died an accidental death inside the premises.
It's not Lotasil police.
Yes, lordship.
So we'll fix it on Monday. What is PD court learn it? Senior counsel, 65.
Lordship, can it be on 17, lordship?
Also heard Mr. SH. Access 2023. Bring to front of bail connection. Second one. Spoke 38, small of ENS call for a city, let the matter fixed on 15th of June.
God bless you.
May I please, your lordship? So say allegation is serious and he is behind the bar only for 12 days. So my lord, I am not pressing to the my lord, CD may be called for.
Heard Mr. G. so much, the Learned Council is doing for the accused and can also heard as the says for the Learned Deputy for the safe is an yes, bring for front of bail the accused applicant in connection with ES case number 7 post 2026 verse 64 PNS call for a city letter fixed on
After vacation, lordship. My lord.
no bail matters cannot go on 24th. 24/6.
My learned friend is asking
15,
for
my lord.
after 15.
15.
Bail matters cannot be given like this. I mean, we cannot post it after 1 month or 2 months or something like that.
Oblige.
If you are there or there, if you're not there, there's somebody engage somebody else.
Oblige.
Let the matter be fixed on 24th.
Oblige.
24, no?
Well, in this case, the connected bail application 1476 is fixed on case diary on 17/6/20.
17 to Rasa.
Correct. You also got a without case diary, it will be difficult to consider. It may be difficult.
Hard means to be decoded. So hard. One, two, three, stroke 305, bracket small c of DNS 202. Let that case, let the matter, call for the city, let the case, the matter be listed on
17.
on 17/6/2026 along with along with bill application number 1476 stroke 026.
We are different. I should have put it.
Five.
May please, your lordships. So, my lord, a connected bail application number, my lord, 152026, my lord, fixed on, my lord, Monday. Already, CD has been called for, my lord.
Same FIR.
Same FIR, my lord.
Third Mr. Samet Kalanet. Also heard.
15th, no?
15 John.
Monday.
Of BNS program to bail to the in connection with other of these case numbers. This the 6189 in the small bracket 2 stroke 109 bracket stroke 117 of BNS 202. All for the city, let the matter be displayed. Along with which
Along with medical report, my lord. But along with bail application number, my lord,
along with
152026.
15206. Let the matter be listed on when
15.
15th of June, my lord.
15 on 15 on Sunday. Along with-
Obliged, my lord. My lord.
Item 6.
Please, your lordship. Lordship, this is Hattigaon police station, lordship. So, city may be called for lordship at this stage. City may be called for lordship at this stage. Okay, FIR is at page 13.
RMS SC Ahmed Dalanet Council. Is an application under your DNS for grant of bail connection with Hattigaon PS. Hattigaon PS case number 78/26 section 117 stroke 35 stroke 305 stroke 308/2 stroke 329 bracket 4 of BNS 20. All for the city. When do you
22nd.
22nd.
please let the matter be fixed on 27.
Yes, lordship.
May it please your lordship. On this regular bill application, the SJI my lord finds at page 12. May I read that?
Yeah.
In normal cases, I would not have asked more, but this would be something different, Miller, because the procedure followed by police, the procedure followed by the police.
But no, that if there is something wrong in the procedure, that CD will reveal that.
Yes.
Not on that, Miller. The lordship plays me for a moment, Miller. For a moment, Miller.
Yes.
I understand. He said he has to be called, but for a moment.
Yes.
The Caesar list at page 24. Suspected beef cooking pan weight 415 grams. And my rejection order at page,
Your rejection.
my earlier bill rejection order, Miller. Lordship finds the type version at page 22. May I read that, Miller? I have perused the case record and the case diary. The facts of the case is that the accused person has been charged of cooking beef in a public canteen on 22, Miller. 22.
862026.
My lord.
Yes.
Married. Later on, CD received, I have perused the case record and the case diary. The facts of the case is that the accused person has been charged of cooking beef in a public canteen. On perusal of CD, it is seen that the said suspected beef is forwarded for forensic examination and the report is yet to be received. The IO has also objected to the bail. Considering the state,
We'll call for that.
but so far as this forensic is concerned, it is not even connected with the beef. Whatever meat is concerned, it will be covered by the Food Safety Act. And it is a detailed procedure done when the power of seizure.
We'll see what is there in the CD.
yes,
Will reveal. Mr. Bonik, no, nothing will be given as of now.
Yes.
Third, Mr. S. Bonik, the learned senior counsel, assisted by Mr. Soinfo. Learned counsel appearing for the accused applicants, also heard to the S.H. Bora, the learned executive for the state, is an application under section 43 of BNS 202, BNS 202, praying for grant of bail to the accused applicant in connection with the Paisley PS case number 140/2026, sections 299/1961 of BNS. All for the CD, let the matter be fixed on
24, Lordship. 24,
23rd or 24th,
Twen-
23rd,
23rd.
23rd.
With the report,
See the,
with the report.
let us see the CD, then we'll.
Lordship.
Lordship.
May I please? Well, this is a dowry death case. My time behind the bar 68 days, my lord. This is a case of dowry death, my lord. Time behind the bar since 68 days. FIR is at page number 10, my lord.
Okay, we'll call this.
My lord, this is from Kamrup Nagar.
Mr. A. Panamanik, the learned counsel, appearing for the accused applicant, also heard Ms. S.H. Bora, the learned APP for the state. This is an application for section 483 of BNS.
22nd.
Means 20. In connect, grant of bail, like, in connection with Nagarbeta PS case number, 2026, with 2 of BNS. Almost that's fixed on 25th.
25th.
My lord, kindly have 19, if possible, my lord.
20. So many matters have been listed.
Well,
It will be difficult.
Please, your lordship.
Hmm.
Lordship, this is a bail application in connection with Vishwanath Chareli PS case number 11226. Lordship, may I call for the case, lordship?
Artemis Swens, the learned counsel, appearing for the accused applicant, also having Ms. S.H. Bora, the learned APP for the state, these in BNS. Paying for grant of bail to the accused applicant in connection with Vishwanath Chareli, this case number 112/2026, 117, 2/127, 35 of BNS. All for the CD, let the matter be fixed on
26th, Lordship.
20, lordship, another similar matter was fixed on 23 June. Same PS.
23.
23.
let the matter be fixed on 23 along with number
152826 BA.
BA 15
28.
1528 of 2026 along with that.
Obliged.
May I please, your lordship? Pre-arrest bail application, lordship. FIR is at page 15, lordship. 6-page long FIR, lordship. Start from page 15, lordship. FIR is basically lodged by a company against one employee, Amit Kumar Rai, and present petitioner is the wife of Amit Kumar Rai. Lordship.
What is the allegation?
Allegation against me is that the Amit Kumar Rai, while he was employed, he has received sum of money in the name of selling electronic goods and receiving sponsors, and the amount which has been received in the name of, in the account of the present petitioner, who is the wife of the employee of the complainant, lordship. The specific part of my allegation is that, lordship, page 16 from para number 7, lordship.
We call for the CD.
PD, Lordship.
May I submit kindly, lordship? Lordship, present petitioner is no way connected with the offense, lordship, and she is a housewife and recently shifted to Gauhati along with her husband.
Litigation is there from the FIR. Lordship.
And the next, the birth certificate of the child, lordship.
So heard It is for the learned APP for the state. This is an application number 483 of PNS. For PRS.
Protection may be given, Lordship.
Accused applicant in connection with dispute case number 345/2006/6 bracket 2/318/4/336/3 612 All for the CD, let the matter be listed.
Some protection may be given, Lordship.
On
23rd.
of June. No protection.
Wait, please. Here, my lord, 103 is there, my lord, so CD may be called for, my lord, this is. Yeah, and this is a bail application, my lord.
What is the allegation?
Election of my lord 103, my lord. FIR, your lordship will find at my lord, page 9, my lord.
CD along with the postmortem report will be required.
Hmm?
CD along with the PM will be required.
Mr. Borua. Hi, Borua. For the state, this is an application for your PNSS for transfer here is built used connection with Lalu PS case number 34/2006 registered under section 1031 of the PNS 2020. All for the CD along with the postmortem report. Let them be fixed on 24th of June.
Obliged, my lord.
Please, your lordship, to kindly pass over this matter for a time.
Pass over of all the time and leave.
There is on lags on court number 16.
Don't do it.
Yes, please, your lordship. FIR, your lordship will find page 9. There only non-bailable section is lordship 87. Lordship may kindly see that regarding allegation regarding kidnapping part. Because in the FIR itself, it is mentioned that she returned at 2 p.m. after kidnapping, and in fact, they are both related, lordship. And there was relationship between accused number 1 with the victim girl. And they wanted to break their relationship. Accordingly, he lordship requested her to meet him for last time and to discuss the issue. The family member lost the case. Girl is also major, lordship. Admittedly, during that period, that girl was with accused number 1, lordship, but
You go there and possibly take somebody, I mean, this
No,
is
not forcefully,
not
lordship.
for fun you are doing it.
no, not for force, lordship. May I kindly see my paragraph 4, lordship. On that day, he wanted.
Doesn't matter at all.
Oh, that is, lordship, some relationship was there. That is admitted fact, lordship.
That doesn't mean that you will go forcibly to somebody's.
No,
place.
forcibly not taken,
And-
lordship. He wanted
Well,
to.
the city will reveal
Some particular, because already she is recovered, lordship. No purpose.
no protection at this stage. Heard Mr. Priya Ahmed, the learned counsel appearing for the accused. Also heard Mr. R.J. Burwa, the learned appeal for the state. Is an application of section 4 of PNSS 2 of PNSS granting for praying for grant PRS bill to the accused applicant in connection with Databari case number 78/2026 registered under section 229/115 in bracket 2/87/351 of BNS 2023. All for the city, let the matter be fixed on 25th of June,
Obliged. Can it be 24th?
24th of June.
Obliged.
May I please, your lordship? Lordship,
Last one.
may I please, your lordship? The petitioner before your lordship is a teacher at a government school, lordship. Here, lordship, the FIR is completely false so far as the petitioner is concerned. There are two parts. And Lordship, the letter is about the father. What happened, Lordship? The teacher has a son who is now arrested. He had a relation with the victim girl. Some people found them on the street and brought them to the home of the petitioner, his parental home. And forcefully, the girl entered into their house. The people compelled them to keep her at her house. His brother is an advocate at Bongaigaon. He sent something and he told his father that let her keep here for the night. And on the night, taking advantage of the night, the boy, his first son, he fled away from home. He is studying MBA in Kokrajar. He went to his hostel, my lord. And since then, till that, he never returned. After 7 months of staying at that house, the family members of the victim girl executed a marriage deed, which is at page number 19, Annex 3, forwarding report, brief fact of the case, paragraph number 1. May I read, my lord? I will come to the FIR.
No, okay. I mean, I will have to, this case, I will have to, there are a lot of complications to look into this.
Lordship, yes, Lordship, CD may be called for, but
CD
Lordship,
allowed one cases.
being a government employee and a teacher, Lordship may kindly protect this man, Lordship. And the VDP, the secretary of the VDP, he was also present.
We have kept her. Why? 7 months in your house. Why?
She never left. The
7 months.
the father,
Supposed to keep somebody like who is not known to-
Lordship, the father who is the teacher, he regularly objected to this.
No.
And therefore, this allegation brought against him. And in the daytime,
7 months you keep an unknown girl in your place.
Lordship, he regularly objected to this. And that's why this allegation brought,
Mr. G.
that's why, Lordship, this allegation brought against him.
Appearing for the accused applicant also heard Mr. R.J. Burwa, learned APP for the state. Is an application under section 482 of BNSS paying for grant of anticipatory bail to the accused applicant in connection with Marichar Police Station case number 11/2026 under sections 318 bracket 1, 61 stroke 75(1) of BNS. All for the city, let the matter be fixed on. Burwa went before vacation.
Before vacation, Lordship.
Before
Lordship, being a
vacation, my
government
lord.
employee and teacher, Lordship,
24th of June.
at least, Lordship, protection may be given.
No, see, unfortunate things are that like they are these days. In our times, the teachers were supposed to be the gods, but these days, I think the teachers are more into doing other things than teaching. So that is the problem.
24 6 months.
Please, Lord.
My lord, earlier your lordship rejected this petition, my lord. But I have come before your lordship because all the persons have been granted prior bail, my lord. It was a group case, my lord, and your lordship has observed in your own judgment, page 36, that because of group case, my lord, the counsel appearing for the informant submits that the involvement of the accused applicant cannot be denied, as the same have been already been pointed out by the learned additional public prosecutor. The case that in this case has been produced before this court of the learned additional PP, having found sufficient prima facie incriminating material relating to the involvement of the accused person, namely such and such and such and such and such. They can be if the opinion in that they can be granted ancillary bail at this stage, according to the aforesaid Abdul Gopur and Akiro 1 and Mujibur Rahman, all these 5 persons have been granted bail of 50,000, arising out of all these conditions. And my lord, similarly, AV number 621, 905 and 7671 of 2452, all they have been granted protection, my lord, under prior bail. One is made absolute also. And my lord, my actual name is Jahanuddin Sheikh, but in the FIR name has been reflected as Jahangir Alam. I am not Jahangir Alam. My father's name is also tallied.
So if you are not Jahangir Alam, why are you approaching the court?
Because police is the.
You are not Jahangir Alam. You tell the police that I am not Jahangir
Alam.
Alam.
Listening to me.
You are not Jahangir Alam. you're a different person, then why? There is nothing in the case then.
My lord, his name,
Saying that you are not Jahangir Alam, then what is the apprehension?
my lord, his
My
name in the FIR number, my lord, serial number 12, my lord.
Yes, it is name is
Jahangir
there.
Alam.
I am not as Jahanuddin Sheikh. I am Jahangir Alam.
Let the case diary reveal, my lord, let the case diary be called for me.
You yourself writing Jahanuddin Sheikh alias Jahangir Alam.
Well, I have to write, my lord, because that is I have police is tracing me, that's why.
Okay, heard Mr. S.C. Biswal and counsel for the case applicant also heard Mr. R.J. Borwal already pay for the state. Is an application under section 44 BNS. Connection with PS case number 02569
अरे तो मान का सब केस
stroke 190 stroke 191 stroke
मान का सब केस
stroke 109 stroke 118 stroke 103 of BNS 2023. All for the case diary letter will be fixed on 23rd of June.
Not 23rd, let it meant 24th.
24th.
Better was. But the saying that I yesterday came, my lord, your lordship was pleased to grant the bail that was the headmaster of the school.
City.
I think in this case, but one thing is he's a businessman, he was present in the occurrence, my lord. Admittedly, only because, my lord,
Okay, when did the other cases fix?
other case also disposed, my lord. So that he was a headmaster of the school, your lordship.
Disposed of
Done
yesterday.
this.
The bail was granted.
Yes.
Yeah, how is he involved, this person?
The present person is a businessman, my lord. One of the person who was present in the place of occurrence, he telephoned his father to go there, my lord. His father, because he has taken me with my scooter, my lord. I have gone there and I have found that the fighting is going on. And my presence came in the picture, my lord, in the CCTV camera.
You will call for the.
That's why, my lord, I am apprehended here.
We'll call for a CD in this case. Or Ms. HRS Chaudhary, the senior counsel, assistant special, so well and counsel for the accused applicants also heard. Mr. R.J. Borwal, the previous state, is an application on the section 44 BNS, praying for this way, which we will case number 111-206. Placed under sections 3294 stroke 189 bracket stroke 117 bracket stroke 118 stroke 109 stroke 304. Yes, all for the city. Let the matter be fixed on 23rd of June.
All right.
Next day.
The FIR which is lodged against us, your lordship, will find at page 16.
Page?
16.
16.
Lordship. There is no specific allegation against other accused persons, against other petitioners, except petitioner number 6. Except petitioner number 6, against others, there is no specific allegation.
How many people are?
Here, lordship, 10 petitioners are before your lordship. That main accused number 1, 3, and 5 are already arrested, lordship, with whom the incident occurred.
1, 3,
and 5. Page 20 is the FIR.
Mr. Ahmed will call for the CD in this.
No, lordship, may kindly say
Will not
20.
We will not incline
Right.
to any as of now, but we will give you some.
And Lordship, that main dispute is regarding Lordship accused number 1, 3, and 5. They also sustain injury. That your Lordship will
On
find
this
page
case, it's
29.
like, the group gathered and tried to kill him.
No, that page 20 and 29 will make it clear that it is the accused number 1, 3, and 5 with whom Lordship the incident occurred. Because wife of the
We'll see like who are the involved people. I mean, we'll see the city.
accused number 3, wife of accused number 3 lost the FIR page 20, Lordship, admitting that it was between 1, 3, and 5. And Lordship, if your Lordship pages
Those people have been named there.
and forwarding report page.
I heard Mr. A. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. Ajay Burwal Ahmed, APV for the state. Is an application under section 482 of BNSS 2050, granting for paying for grant of 3 years where paid to the accused applicants in connection with manufactured PS case number 85046. The section 191 bracket 3 stroke 109 bracket 1 stroke 115 bracket 2 stroke 30 bracket 2 stroke 117 bracket 2 of BNS. Call for the CD, later matter is fixed on 24th of
But 24/7 matter, see, 20, let it be on 25th month.
25th.
Problem.
Not in this case, there is no case registered against the petitioners, Lord. But the police is raiding their house and repeatedly, Lord, running after them in connection with an incident that your Lordship will find at Annexure 1, that is page number 10 onwards. So at this stage, Lord, report may be called for whether any case is registered against the petitioners in the concern. A report may kindly be called for.
For what?
Because as of date, we do not have any instruction that the case has been registered against us, Lord. But the police are running after us.
I mean, without filing any FIR, you just come to the court. Nothing will
No,
be
Lord,
done.
the incident I have narrated at Annexure 1, that is page number 10, Lord.
Where is that?
Yeah, page number 10. Lord. Because in this case, what happened, the Lord, a girl forcefully entered into the house of the petition number 1. Lord.
The girl who forcefully go to the house of the petition
My
number
Lord.
1.
At night, Lord.
Yes.
Lord. Then there is a village panchayat, Lord. That the allegation that she was in relationship with the petitioner number 1, that could not be, Lord, true. And therefore, the villagers set them free, Lord. But after that, Lord, the girl, Lord, the allegedly, Lord, lost an FIR before the police station. But as on date, Lord, there is no case registered against them. Police are running after us, Lord. I have stated the entire incident in my application, Lord. That was filed before the Lord, Superintendent of Police, Lord. So my limited prayer that at this stage, Lord, since no case is registered.
No way. There is no case registered, no apprehension. What apprehension you have?
Otherwise, Lord, the police are running, we are evading, Lord.
That always he makes statements like that. Ultimately, it is found out there is no case for filed. You just simply, on the drop of the hat, to the High Court, filing a case.
Lord, the fact is that we have been run after by the police, Lord. That is the thing that brought us to the before your Lordship, Lord. If there is no case, Lord, then the police is not supposed to.
We are not supposed to spend judicial time on this.
My Lord.
Without filing any FIR, you will just come here and file an anticipatory bail.
Because honestly, my Lord, speaking, if we have no apprehension, my Lord, or that if the police are not after us, then definitely we would not be approaching this court, your Lordship.
Subsequently, she started opening her heart towards the petitioner number 1. What does it mean? Opening her heart means a surgeon or something or what?
My Lord, actually, that she tried to be.
She cuts her heart and like shows to people.
Maybe that she was expressing her love for the petition number 1. Paragraph 6 and 7, my Lord, that On 10/4, my lord, he entered into the house, my lord, at about 11:39 p.m.
This plan is filed by whom? Page 10. Who has filed this?
The petition number 1, my lord. With all respect, my lord, even if it is admitted that the petitioner number 1 committed some offense, so the police has the right to register a case against him. He may face the consequences.
You stated that FIR has been filed. Where is that then?
No, my lord, FIR was not accepted. My lord.
Hmm?
That was not accepted. And therefore,
What is your apprehension now? Nothing is there. All made up story. I will not entertain this application. Heard, Mr.
A. Ali, my lord. A. Ali.
A. Ali, the learned counsel appearing to the accused applicant, also heard Mr. R. J. Burua, the learned AP for the state. Is an application under section 484 PNSS 2023, praying for grant of arrest bail to the accused applicants as they are apprehending that a case has been filed against the accused applicants by whom?
By one, my lord, Fatima
By one?
Begum, my lord.
Hmm?
Fatima Begum.
By one Fatima Begum. This court has Fatima Begum. This court has specifically asked the counsel appearing for the accused applicant about the details of the allegations and the case that may have been filed by the aforesaid Fatima Begum against the accused applicants. However, the counsel for the accused applicant did not divulge any details. This court has gone through the contents of the instant anticipatory bail application, and after having found that there is no such apprehension of arrest of the accused applicant, time of apprehension of the applicant. These days, the instant bail application is AB application is rejected in this one.
I am obliged.
It come to the court just like that drop of a hat come to the court and say that there is an FIR will be filed against you or you are apprehended. No, those things will not do. You'll have to bring in certain serious apprehension that you'll be arrested.
Fine. Obliged.
May I please your lordship? 482 application, my lord. My lord, the petitioner before your lordship is a proprietor of an entity who deals in batteries, my lord, old and new batteries, my lord. My lord, the registration certificate, the GST registration certificate, page number 20, my lord. Now, my lord, the allegation against the petitioner is this, my lord. The SI of the Howley PS has filed an FIR alleging that he was possessing, concealing, and disposing old the batteries, my lord. 825 batteries was found. My lord, as I stated that he deals in old and new batteries. From page number 23, my lord, is the cash memo of the battery that he bought from in bulk from different entities, my lord. So there is absolutely no commission or offense here. He was lawfully dealing with this.
What batteries are this?
My lord, these are old batteries, my lord. What happens, my lord, a battery dealer,
Old battery, a new battery costs how much?
new battery, my lord, I think 5,000-6,000 probably.
It depends upon the size.
It depends. There are different kind of batteries, my lord. So what, my lord, a battery dealer deals, my lord, he sells the new battery and in exchange he keeps the old battery, my lord. That is a practice across these dealers, my lord. So one kind of battery was these batteries, and another, my lord, he buy in bulk and then send them to Uttar Pradesh for recycling, my lord. So in the truck, which is UP number, 300 batteries were found.
My lord, Lordship may kindly, my lord, for a moment, my lord. Lordship may kindly come to annexer to page number 20, my lord. My lord, this is his GST certificate, my lord, probably, my lord, registration certificate. Lordship may kindly see serial number 5, my lord. Date of liability, then, my lord, period of validity, my lord. 1/7/2072, nothing, my lord. There is nothing, my lord. It is valid from, my lord, 1/7/2072 till when, my lord? Thereafter, my lord, from page 24 onwards, my lord. This item, my lord, cash memo, my lord. In purchasing battery, my lord. Lordship may see the quality of the cash memos, my
The
lord.
learned counsel paying for the accused of him or regarding charge of overall and APP for the state. This is an application under section 280 of the PROCEEDINGS. Praying for pre-arrest field. Use applicant. Connection only to this case. Use for 6 after sections. Please read bracket 2 stroke 317 bracket 2 stroke 61 bracket 2 of BNS. All for the CD.
May I just make one humble submission, my lord?
All for the CD, let the matter if fixed on 25th.
My lord. Grateful, my lord.
May I please, Lordship?
Lordship, Annexer A, Lordship, FIR, dated 3/6/2026. PLS bail application, Lordship. Page number 10.
Come on.
May I please to read this FIR, Lordship? I do hereby want to inform you that
Once. Yes.
yes, in regards to the same Lordship, the fact is that Lordship, your Lordship, this is the cross FIR, Lordship, filed by the police personnel against us, Lordship. The fact is that, Lordship, whenever Lordship, one of my friend, such Lordship, went to the officer in charge, Lordship, to lodge and apply, stating the fact, Lordship, that is the annexer D, page number 13, Lordship. Can you please, Lordship? May I please to read this FIR, Lordship? This is
Who is the police officer? Dulumoni Patel.
One police officer also got arrested, my lord. And the person who might have lost the information, he was also arrested, my lord. Vikas Saman.
Oh, sir.
but the actual fact is that may I please to read this FIR, cross FIR, Lord?
See that case diary. I mean, that is something we cannot do. Yes. Mr. I'm a learning council to pay the case also heard. Sarji Burwa Learning APB for the state is an application just 44 PS link for grant of PS where the applicant in connection with this police station case number 357/2026 under 732B, 3, 5, 79 and 121 of BNS 2023. All for the CV let the method fixed on.
Lordship, interim may can be granted, Lordship. In these cases, Lordship, one doctor, Lordship, and another one is the officer, Lordship, presently discharging their duty as a officer's, Lordship, government employee, Lordship. So, in this, the fact is the very different, Lordship.
That's what it.
No, Lordship, interim may can be granted. Lordship, can you perish my FIR, Lordship? What is the actual fact, Lordship? Annexa B, page number 13, Lordship.
In there.
Lordship, actually, Lordship, what happened, Lordship? Whenever
In that we have passed the order, we have, after seeing that we have given the order, we have given a short date, we are not going to give you any increment this case.
but Lordship, in this case, Lordship, particularly violation of our fundamental right, Lordship.
Maybe fundamental right is if I want to.
Lordship, whenever we are standing over the base,
we'll see that.
whenever we are standing in a public place, Lordship, suddenly 10 to 12 police personnel came to the place of the occurrence, Lordship. At that time, Lordship, without any Lordship cause inconvenience, Lordship, one of the DSP is present, Lordship. He is also my friend, Lordship, and the phone number of persons, Lordship.
But we heard you. I mean, like we'll heard you. We have heard you. We have given a short date, 22nd. The CD will come. We'll see, and we will consider your prayer. Not now.
Where is? But due to law and affairs for last 7 years, they came to Gauhati from Gugamukh on 18/4/2026. There's a law of affairs between them for 7 years.
And 18/4/2026, they came to Gauhati, my lord, with intention to marry, my lord. And when they came, and after staying for 1.5 months, my lord, they returned back, my lord, on 8/5/2026, my lord. And when I reached at Gugam, my lord, the parents of the victim, my lord, took their home, took her to their home. And after that, my lord, took to her home. My lord. And after 1 month, my this FIR has been lost. Page 18, my lord. Like this case, custody is no more required, my lord. This. My lord, everything is, my lord. The girl is recovered, my lord. Girl herself stated that there is a love affair between them, my lord, for more than 7 years.
That is true, my lord, but she was taken, my lord, and she was kept, my lord, for around,
He came to on, my lord,
around 1.5 months, my lord.
and my this FIR has been lost, my lord, 4/6, my lord. She was abandoned 8/5/26, and this FIR has been lost, my lord, 4/6, my lord. And now, my lord, the father of the, my lord, petitioner, my lord, took the police, my lord. Last 2 days, my lord, he is in the police station, my lord. The father of the petitioner, my lord. My lord, this is in this case, my lord, father custody is may not be required, my lord. Yeah, herself stated that, my lord, she went, my lord, staying more than 1.5 months, my lord. And FIR has been lost after more than 1 month. Even I am ready to marry, my lord. The parents of the girl, my lord, opposing our decision. Both are young age of my lord.
How old is the girl?
20 years now. 20 years.
20 years.
My lord. And boy is 24 years.
Pardon, sir, coming from the land of the so-called as a whole of the this is an application of such code. For two of the NSS 2023. Being for example, of years way to go through the mechanics of the before. Was last 4/6/2065 informant by the informant releasing that use applicant with false promise of marrying her to Gauhati between 4/6 and kept for 1.5 months. 1.5 months. That the accused applicant and the informant were in a long relationship for 7 years. Simple and that 8/5/2026 to 6, the accused applicant after torturing her physically and mentally brought from Gauhati to and abandoned them to stop. That she continued to flirt family members and they are proceeding on history. The learned counsel, waiting for the accused applicant submits that both were in a love relationship and both the accused applicant and the victim and the informant were involved in a love relationship and for the last 7 years and the accused applicant in fact is willing to marry, but our family of the girl is not allowing them to get married. So, the father submits that the accused submits that the victim girl went voluntarily with him. There was no force used by the accused in taking her to the the father submits that both are adult and they both willingly went to Gauhati. The learned counsel submits that since the girl is already back home there is no requirement of any custodial detention of the accused applicant. Case. In view of the person, the accused applicant should be granted bail in this case. Mr. Arjun Gowal, the APP, on the other hand, proposes the bail or prayer for the bail of the accused applicant. This court has gone through the legal words to problem for this case and also heard the submissions made by the counsel appearing the respective parties. Taking the entire facts of the case, this court is of the considered that the instant the application should be allowed accordingly. Accordingly, it is directed that the event of arrest of the accused applicant by the arresting authority in connection with the token of registration case number 27/6, we shall be released on garnishing of the bail bond of rupees 30,000. This will give rise nature to the satisfaction of the arresting authority, subject to the condition that the number one accused applicant shall appear before the investigating authority within a period of 10 days of passing of this order. Number two, the accused applicant shall cooperate with the investigation and shall and make himself available as and when called for the investigating authority. Accused number three, accused applicant shall not try to get in touch with the victim girl and try to influence any witness that may be involved in the incident case. In view of the in the above terms, the instant ABA application is disposed of as about.
Well, my objection may be recorded.
I've recorded that you have opposed.
Diploma.
May I please, Your Lordship? This is a free and fair application, and basically this is a landlord-tenant dispute. Informant happens to be my tenant, and I am the landlord. Now, what happened, my lord? Petitioner number one is a general manager of Numaligarh Refinery. He has a residential house at within the jurisdiction of dispute.
One.
Yes, my lord. And the petitioner number two is also my tenant and working in the media house. Any news? Now, what happened, my lord? My lord.
You are the owner or tenant?
Owner. I am the landlord.
You are the landlord.
Landlord.
And this petitioner number two is the
tenant.
tenant.
He was also implicated in this case, my lord.
Hmm.
What happened? For renovation purpose,
Let us see the affair.
there is no FR, my lord. There is apprehension because I have lost the FR.
What apprehension you have?
My lord, police are searching in my house and also repeated phone calls. I have categorically mentioned all these things, and my lord, I have lost 2 affairs against the informant. Kindly come to page 22. This is my affair. What happened on that day? And also my wife also lost 1 affair against the informant. He also subsequently come up with 1 false affair. Now, my affairs were not registered till date. Is 23, my lord. Para 8. He assaulted all these people. The informant is not happy because I directed him to vacate the premises for renovation purpose. Now he is not vacating the premises and thereafter come up with all these allegations.
Where are the allegations?
Allegations are, my lord, police are directing me to appear before the police. My lord, I am holding a general manager post, my lord.
What are the allegations?
Report maybe.
You tell me what are the allegations? Why police has come to you? There has to be some reason.
They just directed us to appear
Go
because, my lord, kindly no coercive action, my lord.
Go and appear.
Till returnable date, my lord, no coercive action. Report may be called for, my lord. Very humble. Otherwise, if I was arrested, my lord, my job will be in stake. Then suspension and DP, all these things
You
will
should come before the court with certain genuine facts.
Yes, my
certain
lord.
materials
Yes, my lord.
to substantiate
Yes.
that you have a reasonable apprehension. You simply come to the court that like I have been called by police. Where are the things? Wait a minute.
No, it is there, my lord. Kindly come to my petition, my lord.
I'm seeing your petition only. Nobody else's petition is there.
No.
It's your petition. Tell me where.
It is page 11, my lord. Page 10, para 11. Although there was no notice was served to me, but police repeatedly harassing me and asked me to direct me to appear.
Where?
It is there, para 11, my lord, page 10. Also in page 9 also. So, my lord, there are several judgments, my lord. Simply without FIR, what I am just want to submit, my lord, simply apprehension, petitioner can approach the honorable court, my lord. Report may be called for, my lord, in this case. Everything will be clear. All the activities were recorded in the CCTV. I have installed CCTV, my lord. Everything will come out. Only cause of trouble is that I'm holding some official post, my lord, and that will be in stake if police is taking some coercive action against me.
Where is your statement that you are apprehending arrest?
It is there, my lord. It is, my lord, in page, kindly page 9. Against the concerned police authority have been searching the petitioner for arrest without deciding the matter proper way, without hearing the petition. I am 53 years old, my lord. I have no criminal background. Yes, my lord.
You're an old person.
Yes, 53 years. 53 years, my lord.
53 years is old.
My lord.
Yes, Mr. Burwa. He said
Why not?
53 years is old.
Yes, my lord.
Now what is
Think-
done?
My lord, my humble submission, my lord, even my lord, if the police is searching him, my lord, he should have must have received some notice, my lord. Because my lord, if,
No
the,
need
if
to
the
accept,
offense is
my lord.
committed, my lord, it will become below 7 years, my lord. And below 7 years, my lord, the notice is 36 notice is my lord,
Call for
mandatory, my lord.
clear, my lord.
Question is
What-
that there is no such specific allegation that my lord, why he is, my lord, apprehending arrest, my lord.
No, who will take the risk,
Mere
my lord?
apprehension will not do, my lord. The apprehension has to be genuine,
Is
my lord.
there, my lord.
To give some protection.
If you lordship want submission on this point particular, I will come up at 2 that simply,
Submission?
my lord, regarding without FIR, anticipated bail may.
Yeah,
Fine.
that is true. That is true, my lord. Without FIR,
Reasonable apprehension. And how can I
But in this case, my lord, in this
reports
case,
be called for, my
he has to
lord? What my
make up
prayer
some
is,
case, my lord.
only to call for a report, my lord. Everything will clear.
Why should court waste the court's
No,
time?
this is my humble submission, my lord.
Why
Because
should why didn't you go and find out what FIR has been filed? You are saying that the FIR has been filed.
yes,
Why
my
didn't you
lord.
go and find out?
Yes, they are calling me that directly
You go and
me
find
to,
out
because
what
my
is that?
affairs were not registered till date. I have annexed my 2 affairs. Page 22 and 24 is my affair lost by my wife. Although they have acknowledged the affair.
My lord, sometime, my lord, police try to settle the matter also between the parties, my lord.
No, that is not the way police should do it. Na? Police should have issued a notice.
Notice.
So notice, my lord, if there is no case, my lord, that is why, my lord, police might have, my lord, asked him to appear, my lord. It is not that, my lord, always police will, my lord.
My lord.
Hard distance showing. Your name?
PK Sharma, my lord.
Sharma, the learned counsel, is applicant also heard. Mr. RJ Burwa, the learned APP for the state. This is an application under section 482 of BNSS complete paying program to pay this bill to the accused applicants. Applicants as the accused applicants are apprehended arrest in connection with a dispute relating to landlord in tenancy issue. The learned counsel paying for the accused applicant submits that though in spite of submits that there is an existing dispute about landlord tenancy between the accused applicant and accused applicant and one Mr. What is his name?
My lord, accused
Your
name? Tenant is it's a very long name. Muhammad Abu Said Muhammad Zakir Hussain.
Muhammad Abu Said Muhammad Zakir Hussain. The learned counsel submits that due to such dispute, the accused, the learned due to such dispute, the accused applicant as well as his wife already filed 2 FIRs before uh, before the dispute police station. However, the same were not registered.
On 7/6/2020.
Not registered as yet. So he submits that due to such filing of the FIR, he is apprehending that the accused applicants are apprehending that an FIR may have also been filed against the accused applicants as the police is searching for them and calling them to the police station. So, being apprehensive, he has filed the instructive application. In being apprehensive, the accused applicants have filed the instructive application. Also, this court has gone through the contents of the bail application. And heard submissions of all the counsel and the respective parties. So, is taking into account the facts of the case, it is directed that the officer in charge of dispute police station shall submit a report as to whether any FIR has been lodged against the accused applicants, namely Wahidul Amin.
Wahidul Amin and Jahir Akram Bora.
Wait, I'm dictating something. Why are you disturbing?
No, my lord, I'm sorry. My lord.
Do you think I don't know what to be written? What is to be written in the order?
Name, only name.
I can't read the name of what?
I'm sorry.
Jahir Akram Bora in dispute police station. The aforesaid report is to be submitted by the officer concerned to the office of the public prosecutor within how many days?
My
4
lord,
days?
2 days, my lord, or 12, my lord, let it come on 19th, my lord. 19th.
Okay, by 19th, let the matter be listed on 19th. Till that time, right? Till that
No
coercive action shall be taken upon the respondent, upon the accused applicants.
Obliged.
A copy of the order may be furnished to us.
A copy of the registry to the word 840 of the order.
Mass oblige.
May please your lordship. Lordship, this is a regular bail application, lordship.
Yes.
46 days in jail custody, lordship.
Custody for how many days?
So 46 days, lordship. Statutory period is 60 days, lordship. Since case was registered under 143, that is kidnapping and wrongful confinement, lordship. Punishment is 7 years, up to 7 years, lordship. Now, FIR, lordship, will find on page 13, lordship.
Page 13?
Yes, lordship.
Again, CD call for, but we have not received.
Several locations, lordship, CD was called for, lordship. Now, lordship, kindly come to the order that is on page 27, lordship. The girl,
It has not.
girl already been recovered, lordship. That is on page 27. Observation by the court.
It was to come from where? Which police station?
It's from lordship, Borpeta, lordship. Satyabadi police station.
Kindly give a short date.
Now 46 days today, lordship.
These are not coming.
Some are not come back.
Hmm?
I'm praying for a short time. Lordship में उसने kindly fix on 18 man.
Fix it on 18. So we should be proceeded and counsel acting to the accused applicant also heard Mr.
MP
Gustami around 83 for the state. CD mainstay case is awaited. Let the matter be listed on 18th of June.
Deeply obliged.
Deeply positive.
Lost. Deeply obliged.
I live.
CD received man.
My lord, I have instruction to withdraw the petition.
Your name?
Amar Sodial.
Amar?
Sodial.
Heard Mr. Amar Sadival, the learned counsel appearing to the advice of the court. He submits that he has instructions to withdraw the instant bail application. Hence, accordingly, the instant bail application is dismissed from the law.
Deeply obliged.
CD receive this and document.
See this and proceed to this.
May I please your lordship?
Yes,
It has come, my lord.
May I please your lordship?
One thing, my lord, just before that, my lord, here, my lord, final PM report is not received, my lord, because it's a case, my lord, where the wife died in the premises of the husband, my lord, but he has no explanation to that, my lord. So, my lord, it's a case under my lord 302, my lord. So, my lord,
PM report is not
103, my lord.
PM report is not there.
PM report is not there, my lord. It has to be, my lord, because it was sent, the FSL report is also written, my lord. The final PM report, my lord. Because the victim eloped. Yes, ma'am. Victim eloped.
Heard Mr. MSG, देखा the learned counsel appearing to the accused applicant, also heard Mr. Swami, the learned.
Is to the strike money again.
Those civil.
By state.
The extent case has been received, but same does not include PM report. On 25th.
25th, lordship.
Lordship, today is 68 days, lordship. Before 25th, lordship, any other date? 21, 19.
Today is 68 days.
Today is 68 days.
22nd, my lord. 20. If your lordships, my lord. 22nd, 23rd. My lord.
22nd will be how many days?
It will be, my lord, today is
She's saying 68 days. already.
66. Then it will be within 90 days, my lord.
Within 90.
Okay, let it be fixed on 19 June.
Lordship.
19 June.
Lordship.
Obliged.
I'm sorry, my lord. It is not received, my lord.
CD, why CD is not coming?
47 days she is in custody, my lord. Problem is that when if you looks into the FIR, it's not a case. It appears from reading of the FIR, my lord, it's not a case of a suicide, my lord. Now, I cannot be entangled with this case, my lord, with the FIR. What is regarding about the money, loan, money which has been stolen. And there is a brother has given assurance and ultimately it was not paid. And he was not taken to custody. He was not taken to custody also. And there is no suicide note. Apparently, there is no suicide note. The payment could not be made. That is why they are committed to suicide. This is the case, my lord.
CD is not there, Mr. Das. In this matter, CD will be.
Short date, my lord. 18, my lord.
Hmm?
18 or 19, my lord. Next week, my lord.
Let it be a final date, my lord. Otherwise, my
No.
client is also. I don't know what is there in the case. These are liberty of a person, my lord. More than 47 days he is in custody. So otherwise, I would not have said.
See, bring the CD, otherwise we'll go ahead without the CD. Or we'll have to call the.
Let it be 17. my lord.
Cannot go on like this. All the matters, CDs are not produced.
Yes, you know, 17.
Third, Mr. D. Das, the learned senior counsel, assisted by Mr. N.R. Surana, the learned counsel appearing for the accused applicant. Also heard Mr. M.P. Goswami, learned AP for the speaker. Mr. Goswami submits that the CD in the instant case is yet to be received. Stop. Taking into account the fact that the matter is pending for quite a while due to the CD. Due to non-receipt of the CD, a last opportunity is given to the learned AP to produce the CD on the next date. Fixed, it is on
17.
17.
Senior friend wants on 9, 17, my lord.
17.
7.
The matter is fixed on
17.
17. You bring the
Sir,
CD.
deeply obliged.
Go ahead.
Scan copy.
Scan copy.
No, scan copy. Original. CD receipt, my lord.
Lordship, my senior is in another court, kindly the maternity time for time.
Pass it over for time.
কিমান টকা?
Is there is come?
SW has not come in 29, man.
Is there is awaiting? Let the matter be listed on 18 June.
May I please? To anticipate bail application, my lord. In terms of the order of the 9-3, I have appeared before the ION. My statement has been recorded. Lordship will find the FIR page 11. my lord. Maintain love relation for a long time, my lord. When they parted away, my lord, this allegation has come. Sexual harassment and circulating some options photos.
Huh?
I have appeared, my lord. I have not violated any condition imposed by this honorable court, my lord. My statement has been recorded, my lord. May I pray, my lord, that
My lord, before my lord, going to the merit, my lord, I do not have anything against my learned senior friend, my lord. But my lord, regarding this petitioner, my lord, what my lord, he has concealed certain facts, my lord, that he has approached in the trial court, and therefore it was rejected, my lord. Nothing has been, no instruction has been perhaps given to my learned friend, my lord. Because if your lordship kindly see the paragraph 14, my lord, because there has to be a, my lord, certain environment has to be made, my lord. That no other application on behalf of accused prisoner in respect of such and such paragraph 14, my lord. Filed before the Honorable Supreme Court of India or before this Honorable Court, and no application is pending, my lord. So, but
that is,
as per the, my lord, as per the rule, my lord, they
bail
have,
application pending.
as per the rule, they have to, my lord, disclose that there is a petition disposed, my lord, then that was rejected, and the order, and nowadays,
This
my lord,
paragraphs has been provided by the registry.
and nowadays, my lord, order has to be also annexed with the petition, my lord. That is the rule, my lord.
This
So
paragraph,
otherwise, my lord, perhaps, my lord, interim would not have been granted, my lord. There is nothing here, my lord.
This paragraph, my lord,
on that ground,
Fine, but you are supposed to disclose everything.
yes,
well,
because in that ground, my lord, I pray for the dismissal, my lord.
I mean, all bail applications need to contain
Yes,
each and every details.
my lord. Only when I go to the CD, my lord, I found it, my lord.
My lord. Perhaps that is not disclosed.
And apart from that, there is also materials in the case there, my lord. Perhaps the conduct of the, my lord, petitioner is not good, my lord.
Paragraph 14, my lord, that it is a prescribed format of this honorable court, my lord. I have stated so.
But he should have mentioned that like
no, my lord, it was not informed.
Bail has been rejected earlier.
It was not informed. My humble sir. Otherwise, I have appeared before the IO, my lord. My statement has been recorded.
Mr. Goswami, let him go. I mean, we are giving him.
My lord.
My lord, that is perhaps, my lord, subject to my lord correction, my lord. Because if your lordship sees the conduct, my lord, it is not good from your lordship has seen, my lord. And thereafter, after going to the CD also, I found, my lord, he has been harassing this my lord lady, my lord, lordship.
If there are those allegations are there, then
Yes, my lord.
Lordship will consider it.
Because now he had
cooperated with investigation.
But now he had parted way with the boy, and thereafter, my lord, she was engaged with some other boy. This, my lord, this petitioner is, my lord, sending some, my lord, photos, my lord, obscene photos, my lord.
Post the bail.
Yes.
After the bail was granted.
No, before, my lord, what the case
that
is,
the allegation in the
yes, but yes, man. He is sending those photographs to them and to his new, my lord, engaged, my lord, fancy, my lord, and that is also, my lord, not, my lord.
That is reflected in the
photos are, my lord, also, my lord, it is, my lord, modified, my lord. That is what, my lord, and that is how he has been harassing this, my lord, petitioner. Lordship may kindly see. First, Lordship may kindly see the video. The book one. That's my quite my And the other bail that was on BA 15/26, that is before the trial court, and rejected on 3/2. B. Oh, B, sorry, my lord. BA number AB part. Passage. And there is a note in the CDOs. And also, Lordship may kindly see the next. And seizure of the pen drive, my lord, it says, my lord, this abusing and threatening the victim, my lord.
Where is that note?
Regarding my lord, case pending, my lord. Yes, my lord. Just I have not tracked everything.
This pending will be.
No, case disposed.
I have not, I have stated that there is no case pending, my lord. I have not stated that my bail application was rejected.
No, that you should have disclosed, though.
No, my lord.
That's a mandatory thing.
No, this is the prescribed format, my lord.
Format is different, but there is just about pending that format is there, but you're supposed to disclose what.
My lord, my respectful submission, it was not disclosed to me.
Huh?
It was not disclosed to me.
That's why, we are not saying that you have.
My lord.
Yes, my lord.
But that you should come with clean hands, no, to the court. And Honorable Supreme Court has specifically stated the
Yes.
facts, all the facts, everything has to be placed before the court.
Lordship. Only my respectful submission, I have appeared before the, I'll cooperate in investigation.
And when interim order was passed.
Interim order passed on 9/3, my lord.
He was not before the court.
9/3 it was passed.
Seizure part, my lord. I'll take it up at 12. Your lordship is rising, my lord. I can point out the regarding pen drive portion also. Lordship, I'll pay. Yes.
So we'll consider that aspect, whether the bail was dismissed or not. But we will also see that any threatening action on the part of the petitioner after the interim order, my lord. If that be so, my lord, I am not entitled to bail.
Interim order doesn't give you full 100% right.
Precisely. If there is anything, any violation of the interim order, my lord, the petitioner is not entitled for bail. Only my respective permission, I will cooperate in investigation application for as and when called for.
Third, Mr. P. Hazarika, the learned counsel, preparing for the applicant also has 70 to submit an EP state. This is an application by section 453 for DNSS paying for the DNS bill for accused applicant in connection with legal registration case number 02/2026 number 675 296 296 251 of DNS. And I thought it was lost on 14 and informal basic that accused of had been harassing. Well, various instances acceptable for in many groups. Many groups. That she had been polished by the accused of people while she was traveling with. That the victim was being harassed mentally and physically. The accused of reasons, reasons that such harassment, the accused of harassment, the victim is going through deep mental case. See for the police is finding the police station is not going to get 6,074. That license, if I run for this code by the order with the 956 as granted include period is built that is we can direct to here before the investigating officer in PDF of these. Okay, is very interesting. This has been received and the seat is very same is very the learning if you pay for the state submits that the accused applicant has approached his court with dirty guns as he did not disclose about his rejection of earlier bail by the additional district administration just FTC. FTC, not looking for. Taking into account that taking into account this available in the city. In the city, as well as this code without disclosing this rejection of the application. This code is of the considered opinion that the incident date of that 9/3/2026 should be considered. According the incident issue is rejected by cancelling or including for the 9/3/2026. We're rejecting this.
My lord, I was not disclosed that. I'm sorry.
That's very bad on your, part of your client.
My lord. Public.
That's one.
Fifth.
Updated CD was called for. The petitioners are on interim.
CDS now.
CD has not arrived, my lord. On interim, my lord. CD has not arrived on interim. Kindly on 25th, my lord.
CD is awaited. Listed on 25th of January. 25th June. What are Supreme Court is underneath it.
May I please, Your Lordship? In this case, interim was granted and petitioner was appeared before the investigating officer and his statement was recorded. My lord, here, my lord, the IO has paid for one date, my lord, given a communication, my lord. So, the medical report has not been received, so he wants it date, my lord, along with the medical report. As per him, he will send it, my lord.
So many times, too many dates have been taken.
2-3 dates have gone, my lord.
Initially, the order was for 13/3.
Yes, my 16th is.
3 months are over.
Yes, medical, as per the 11/6, my medical report not yet received, so my, it is not.
Keep it pending for
Lots.
some time.
Then my lots 25th, my lord, and same day. On
CD in the incident case is yet to be received. Next CD along with the medical report is yet to be received. The material listed on
25th, my lord. Deputy of Vice. CD received, my lord.
My pleasure. This previous bail application, lordship. Petitioner is on interim bail and pursuant to the interim he appeared and statement recorded, lordship. FIR at page 9, lordship. Basically, allegation is kidnapping, lordship. And the informant is a wife who lost this FIR against these 3 accused petitioners. 2 were arrested, 2-3 arrested, and petitioner number here is accused number 4, lordship. This is a pre-planned case, lordship. Immediately he was recovered, lordship. There is a business deal, and the husband who was dealing the battle nut business and who was required to pay some money in the Meghalaya, he did not pay. That is why he was detained by the garden owner. And for that, he made a call to his wife to give some money to this.
My lord, he is submitting a pre-planned case, my lord. Submitting, my lord. So, my lord, here in this CD also reveals, my lord, that he was taken to some secluded place, my lord. He was confined, and thereafter he was, and the wife was contacted to pay the an amount of rupees 3 lakhs. Thereafter, negotiations was made. Then said that pay 2 lakhs. Thereafter, my lord, the wife called up the police, my lord. Thereafter, the victim was recovered along with 2 persons were arrested, my lord. And those 2 persons, if we go to the statements of these 2 persons, they said that this is the person who is the mastermind, my lord. He has instructed, my, and he is also there along with him, my lord. So crime has been committed, my, that is.
It is admitted to lordship. I have admitted in petition. He was
If
detained
anything
by
is
the
due,
garden owner and the petitioner was there. Immediately the
cannot-
FIR lost and other 2 acres arrested. He was
You cannot
released,
resort to,
lordship.
my lord. If the victim would
only
not have
appeared
been
in
recovered, my
statement
lord, that this thing would have been different, my lord.
I appeared instrument has been recorded, lordship.
He was rescued by the police
Rescued by the police, my lord.
on intimation by wife.
Or intimation by wife, my lord. So you cannot take the law in your own hands, my lord. What will be effective?
Basically, I have stated in paragraph 6, lordship, paragraph for the reason, lordship. The thing is that, lordship, maybe the statement subsequently changed, lordship. The thing is that the informant husband and other 4 accused, they are business persons, lordship. They are dealing with the battle nut. And the husband of the informant accused victim, he was required to pay the amount to the garden owner in Meghalaya. When they all together went, they came to know that he did not pay the amount. That is why the garden owner detained him, asking the money. And then immediately this accused
Who is the
victim,
garden owner?
lordship, this is Meghalaya residing where by the local in Meghalaya nearby the Mankachar,
Your
lordship.
lordship,
This is a
may I
bordering
place
area,
the
lordship.
statement of the other persons to
No statement, I think. No statement. My statement also recorded, lordship. I appeared.
You have already confessed yourself.
Yes, Lordship, that also I admit, Lordship, and it should
There
also.
are other allegations.
Lordship, at this is my custody may not be recorded. That has to be considered and appeared, Lordship. Already appeared.
Third, Mr. S. You have been under counsel been for the accused applicant also that is. Reason application for section 4 would be a process to be named for grant of years bail for the accused applicant in connection with 1% police station case number 26/2026 registered under section 1. Added section 61 of BNS 2. An FIR was lost on 9/2/06. 2651 releasing them on 9/2/06 for about 6 o'clock. The accused persons named in the FIR came to their house and took their husband along with them. So that the evidence of the essential of taking the husband out of the common to an unknown place. Demand the ransom of the peaceful please to the mobile number 8453613679 to our mobile number. To the mobile number. That that the accused of victims and accused persons to kill him if the associate ransom money is not paid. In view of the associate that I hear that forsaken that the fire was caused by the informant and please register the Manipur police station is covered from 6 under section 1 at the corners to 35 of VNS. This call for recording bands to this order. I forgot to get into direction to appear into direction to the accused applicant to appear before the investigating authorities within 7 days. The case that the instant case has been produced in the report, same is produced, comparison of the case study. It is prima facie found that sufficient opinion materials against the accused applicant of his involvement in the allegation that has been narrated in the affair. Taking into account that the instant taking into account that the incident of the 2026 past by public and this court is hereby cancelled. According the instant failure is rejected by this one. 27/28.
CDC, madam. I am on incoming your lordship. FIR page number 11 and XRA laws. And XRA page number 11. There is no specific allegation against us, your lordship. This FIR filed by the block development officer, Lordship. It's a fee is one of the responsible officers. In previous occasion, detailed observation was carried out by the Honorable Court. The Lordship had ordered it 23/2026 in effect. Court order.
Yes, where?
Lordship, Honorable Court has observed details order has already been passed, that is 23/2026, Lordship.
23?
20 March 2026. There is a court order. One observation is already made out.
23?
Yes, Your Lordship.
20?
20/03/26.
Where is the detail order? There is no detail order on 23/2026.
Lordship, maybe in another cases, Lordship, that is Samantha Hazard, 2680, item
Samantha
number
Hazard.
28. This FIR filed by the block development officer, Lordship, he is one of the responsible officer in this case.
So updated case diary has come.
Yes, it has come, madam.
Interim was not given.
Yeah,
Interim-
on interview.
Interim was given, madam.
Where is the interim given?
On, madam, perhaps on 11. This month. 13/11.
Yes,
13/11.
13/11.
Since then, we cooperate with the investigation authority, Lordship. In the meantime, Lordship.
Yes, what is there?
Yes, madam, regarding the CD, my lord, materials against demand. They are the person responsible for preparing the beneficiary list and thereafter registrations.
There was a contention that during the year 2016, 17 and 2022, 2023,
Loss.
he was not with the Gaungura. Gaungura what?
And that as per that, there is also regarding that, there is also a note, my lord, that with effect from one person, my Hemonto Hazarika, they are with effect from 8/3/2019, and another person with effect from 3/12/2021. They are present. I'm just pointing out the facts, my lord. Lordship may kindly go through, my lord, because Lordship may retain the CD, my lord. Just I'm pointing out what is there against.
But also in case.
In the, may I please?
My lordship, Abu Sama, the applicant, first applicant, he joined in his services to 2021. He has been working in his respective post since 2/12/2021. But this is a case in respect of the misappropriate of government fund in the year of 2016-17 up to 2023. Wherein the departmental proceeding itself reflects.
23 again. You are joined in 21.
21, but
it is still 23.
Position is the only Gram Rozgar Sahayat. Only temporarily posting on that particular post. In the meantime, he has no any financial power. The Panchayat Act itself here clearly reflected in Section 29 audit Assam Panchayat Act. So in case of the Gram Rozgar Sahayat, that is Abu Sama, item number 27, he has no rule in regards to the misappropriate of government funds. In these cases, the block development officer itself is the responsible officer, and audit should be maintained each and every year. That is their mountain duty prescribed by the Assam Panchayat Act 1994. But no audit has been carried out each and.
Is there any inquiry report?
Yes, ma'am. There is an inquiry report also, ma'am.
Inquiry report as per the terms direction of the court.
Yes, ma'am. There is an inquiry report. Yes, ma'am, on my lord, regarding 5/9/2025.
Inquiry.
Loss. Yes, Lordship, may I kindly go through the settlement regarding the points which I have, my lord, raising, my lord. May I, one by one, I am saying, my
Inquiry report.
I have flag mark, my lord. How the, my lord, list, along with the list of beneficiaries, my lord, the account number has been changed, my lord. And the money went to the fake beneficiaries list, my lord. Fake beneficiaries who were already, my lord, owner of a Pakka houses, my lord. And one or two, well, there are the statements of the victim also, and also the statement of the other persons.
There was an inquiry asked to be done, carried out by the IO by this court on 22/5/2026.
25.
Whether that is there or not.
There is a, in the note, there is a last note.
It's not available when this case was heard earlier.
Last.
But there was another inquiry was directed to be conducted and submit a report, whether that is there or not.
As per that inquiry report,
you see the order at 22/5/2026.
No, sir. Specific inquiry report as per that may not be in the CD, my lord.
The court is going to consider. The other things are already available.
Last.
Then?
Last. Inquiry.
See, case diary received, but it is submitted by Mr. Das, learned APP, that detailed report which was directed to be furnished before this court by its order dated 23/2026 is not available. Where is that order? What is that inquiry?
My lord.
Sir Goswami, I mean, you read those orders. I mean, there is a specific inquiry report sought from that from the official. I mean, but there is no inquiry report.
Not. A report is, as a report, it is not there, man. As a report, man. Yes, ma'am. Only, my lord,
an inquiry report was called for.
Yes, yes, ma'am.
We are just asking you whether inquiry report is there or not, and
Yes,
why it is not there.
ma'am.
It was passed way back in 23/2026.
23/2026.
All these things were already there in the case diary.
Lordship.
He was not looking for this. Court is asking for another further inquiry to be conducted and report to be submitted, whether it has been done or not. Why he hasn't done that?
I will see to it, madam. I will see to.
No, you will see.
My lord, whether
It is already 23/2026. The inquiry was sought for.
Lordship.
There was an order of this court, and you said that like the inquiry report is there.
But I thought my that is the other
These mistakes.
Lordship.
There was an order, specific order. You should read the orders.
Lordship.
This is not the inquiry report. They ask for a specific report.
Lordship.
And why he is not doing it? Who is there officer in charge or OC? Considering this aspect, the case IO is hereby directed to furnish a detailed report of inquiry as directed by Order 23/2026. This cannot go on like this.
Lordship.
Your IO will not do work. A direction has been given by this court. In spite of that, 3 months back, in spite of that, nothing has been done. No report has been got.
And also, my lord, there is there is an instance, my lord, where they were called for, my lord, they are not coming to the.
So these explanations will not do.
Lordship. That is.
A report was called for by the court. A report should have been there in the.
Lordship. As per order, that has to be there, my lord. I apologize for that.
Heard Mr. M. Saikya, the learned counsel, appearing for the accused, and also heard Mr. M. P. Consuming the learned APP for the state. The coordinate bench of this court by order 23/2026. 2026. Call for a detailed inquiry from the IO. Detailed inquiry from the IO and the inquiry is to be submitted before this court. However, till today, no such inquiry has been submitted by the IO. The last opportunity is given to the IO to submit the inquiry report before this court by 24th of June. By 24th of June. Full stop. In the event of non-submission of the inquiry, the concerned IO has to be present personally before this court on the next date, that is on 24/6/2026. Then the matter will be listed from 24/6. Please ask him to submit a report, otherwise he has to hear the report explaining why he has not done that.
My lordship, engineering mechanical control.
Interim order superstandard shall continue to the next exercise.
May I present?
Yes, there is him, madam.
Allegation was regarding the financial irregularities, my lord. And as per the direction of the Honorable Court, my lord, the petitioner have appeared before the IO.
Borua, is there anything serious?
My lord, yes, my lord, fact of the case is lordship is well aware, my lord. No, fact of the case, lordship is well aware, my lord. Only, my lord, he was the manager, my lord, and he, my lord, approved the loan, my lord. Accordingly, on the basis of their approval, my lord, on the basis of the scrutiny of the documents, my lord, the branch manager, my lord, sanctioned the loan, my lord. But later on, my lord, they have not prepared. But there is an IO note, my lord, that lordship may kindly peruse, my lord. It will do so. It will do so. So some further investigation will be required, my lord, in this case.
So then
May-
they do the investigation. Let her, let.
Let me just kindly peruse, my lord. The second last paragraph, my lord. Down below, my lord. Second last paragraph. Some of the borrower, my lord, they have, my lord, even, my lord, they are paying the installment, my lord, EMI.
Let him cooperate. I mean, he's cooperating with them.
Otherwise, my lord, further investigation will be required, my lord.
He will cooperate with them. First, MS having to with them, I mean, council of things about issues that people also not. What I understand, I really get to. The primary allegation against the the applicant being a manager of the concerned bank without verifying the entitlement of loan, without verifying the qualifications granted, 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 um, granted loans to several persons. The coordinate bench of this court by order of the 2021-42026 has granted interim arrest to be the accused applicant. The direction is with the direction to appear. With the direction to cooperate with the investigation. Learned counsel appearing on behalf of the accused applicant submits in terms of the order which 21-42026. The accused applicant has already appeared before the investigation officer and what his statement is recorded. She submits that therefore, he will continue to cooperate with the investigation and his custodial detention. Mr. R.J. Gauhati, on the other hand, submits the investigation in the extent case is yet to be completed, and therefore at this stage, the PRS bail should not be granted to the accused applicant. This court has gone through the case there that has been produced before this court, as well as heard the submissions made by the counsel according to the respective parties. For taking into account the whole aspects of the matter, and on perusal of the case diary, this court is of the considered opinion that the interim PRS bail so granted to the accused applicant on 21-42026 should be made absolute. Accordingly, the interim PRS bail order dated 21-42026 is hereby made absolute in the same terms and conditions as stated in the aforesaid order dated 21-42026. Instant any application is disposed.
Highly obliged, my lord.
35 my lord, case there was called for, my lord. I was paid for some time to produce the case diary.
Or Mr. J. Islam Jalani for the accused applicants, also have Mr. R.J. Bogol and APP Podolski. Is there in the instant case is yet to be received? Interim order so passed earlier, shall continue till the next date of listing. Break the matter will list on
14-7, man.
Huh?
14-7.
14-7 will be too late.
But otherwise, my lord, 7 matters has already been fixed, my lord, before the bail.
Help. I mean, bail matters, we cannot post it like that.
Then, my lord, on 19, my lord, 19 or 22nd, my lord.
22nd.
My lord.
22nd June. We can have a fixing, please.
So, yeah.
May I please, Your Worship? This is a search matter, Your Worship, and I have been shown as an absconder, and NBWA has been issued against me. NBWA is at page 5050, Your Worship. The non-available sections involved herein is, Your Worship, 326 and 307. But the injury report that is in 41 to page 45, Your Worship, everything shows as a simple injury. Even then 307 has been the case has been registered against them as 326 and
307. And the embargo lies herein, your lordship, under 480 BNSS, where if they appear before the court, since 307 is a sessions tribal, they may be arrested, your lordship. And in this regard, a coordinate bench has passed an order. I have annexed herein at page 46 to 49. The relevant portion at page 48, para 9. May I read you? It appears that presently the case number is pending before the court of the judicial magistrate first class Nauga, and the same being the court of the judicial magistrate first class. Even if the petitioner surrenders before the said court due to the embargo of section 480 clause 121 of the BNSS, he may not be granted bail, and therefore he apprehends that he may be remanded to custody. It appears that the apprehension of the petitioner appears to be genuine apprehension, and the embargo of section 480(1) of the BNSS, and therefore the anticipatory bail is disposed of with a direction to the petitioner to appear before the learned court below. So here also, lordship, the same comes herein. If they appear, they may be arrested, and the same is in the appearance stage, and the next date is on 18th of June. And if he appears, lordship, the trial will also proceed, your lordship. Okay. So I pray before lordship, he may be given the opportunity to appear before a trial. He is ready to face the trial. This is basically a land dispute, your lordship. The FIR itself reveals it. And I have also filed a cross case against the informants. Injury report is also at page 41 to 45, all simple injury.
What is this additional affidavit?
Additional affidavit, your last location, we were asked to bring to record the earlier orders prior to if NBW was issued, your lordship. For additional affidavit was filed to bring into record the same orders.
Yes, Mr. Das.
Yes, Lordship, I have seen that in the injury report, yes, Lordship, it is true, it is simple injury, but it is where it has been there, it is occipital region in 43, Lordship, in head, on head, Lordship. And another person's Abu Bas, it is parietal region. That is of 4 centimeter, Lordship, and 4 centimeter. However, his name is there in the first accused person's name, Lordship, the Saiful Islam. And I have also read the...
Where?
In the Lordship, page 43, it is lacerated over occipital region, Lordship. And the second one, the below, Lordship, lacerated over the parietal region, so on head, Lordship. Moreover, Lordship, in the FIR, I have seen that it is an Saiful Islam, his name is there. I have also seen in the case that the Lordship, he is implicated by the victim's Lordship, that he has beaten him. And moreover, Lordship, if I look into the NBW, there is no wrong in issuing the NBW because it has been region has page in which Lordship, page 50 is there. 50 Lordship. Reason has been there, Lordship. Why NBW has been issued?
Page 50.
Page 50, Lordship. Lordship, got it. Annexure 6, Lordship. Annexure 6, Lordship.
Page 50, no?
50, Lordship. It is in the middle, Lordship. Perusal of the case record reveals that the accused persons have sought adjournments on multiple previous occasions for their appearance before the court till date since 17/7/2025. Considering all aspects, I deem it fit to issue NBW, Lordship. First, it has been issued summons. So there is no wrong in issuing NBW, Lordship.
This is the reason.
And moreover, 307 is also there. That is a matter of trial, although Lordship. That is a matter of trial, Lordship. But on head, on the vital part of the body, Lordship. That is why I reflected on that page, Lordship.
Nature of the injury are simple in nature, Lordship, and moreover, the FIR has been filed by us against the informant also. It's the same has been also been registered against them. And now, Lordship, we could not appear for the court because of the embargo, Your Lordship, as we have mentioned in this petition. And therefore, we are ready to face the trial now, Your Lordship. The next date is on 18th of June.
What is the embargo you're so talking about? So
Yes, Lordship. 480.
480 of DNS.
DNSs. Clause 1, subsection 2, Roman 1.
Yeah, read out, read out.
DNS.
No, but Lordship, I only want to another.
Don't have a book.
I do not have, I do not.
You do not carry book.
I have not handy with me.
Why? I mean, you have come to do a bail matter and like you don't have the CRPC, IPC and all these things with
I
you.
don't carry lots of files there.
So many cases with you.
When any person accused of or suspected of the commission of any non-bailable offense is arrested and detained without warrant by an officer in charge of the police officer or appears to be brought before the court other than the High Court or the Court of Sessions is released on bail, on such shall not be released if they appear reasonable grounds for the belief. And 481.
Which clause you are referring to?
480 clause 1, 2.
How it will, one is a two is a
No, it's mistake.
There is nothing there. In your case, at least.
Your Lordship, I have annexed court order, Your Lordship.
The
at page
court order,
48, yes, Lordship.
court
And,
order was a different case.
Yes, Lordship. In there itself, it appears.
There was, I mean,
Yes,
that was a case of 304.
304, but the embargo was being,
No, embargo is not there in your case.
the same lies because, Your Lordship, the Sessions tribal matter, it is 307, Your Lordship, is involved here.
Your case is what? Your case is 30.
307 and 326. And other sections
in your
available in nature.
And in your case, you have in spite of issuing summons, you have not been appearing.
Your Lordship, only for that part only we could not appear before the court, Your Lordship. Now we are ready to face the trial, Your Lordship. That particular section, Your Lordship, may give me some time. I will just.
Moreover, Lordship, I want to point out one thing, Lordship. Here in the injury reports, Lordship, one person's report I have not found, Lordship, Azizul Islam.
We'll fix it some other day. You come back with
Your Lordship, I paid 2 at Lordship.
not two. I mean, next week we'll fix it. Hardly so. We are honored the Learned Council, the clinical ethics applicant, also having to take the class and the Learned APT for the state. Let them at the release date on 16 June. We are fixing 16. We come back with proper.
Yes.
My lord.
What?
The affair is lodged on 2014, my lord. In this case, my lord, what happened, my lord? The petitioner was earlier arrested, my lord. He was behind the bar, my lord, for about 18 or 20 days, my lord. Then he was allowed the interim bail, my lord. At the relevant point of time, this present South Salma district comes under the Dhobri district, my lord. It was subsequently bifurcated presently, my lord, and created the South Salma district, my lord. At that time, I was appeared and my bail bond was accepted, my lord. Then I was released on bail. Subsequently, my bail petition was, my interim was absolute, my lord. But my lord, when that all records were transferred to the present district, my lord, South Salma district, my lord, in this record, my lord, which was available presently before the court, my lord, Learned Committal Court, my lord, only my acceptance of the bail bond, that was interim time when I was released from the jail, my lord, that interim bail bond order was in the record, my lord. No order of the present, my absolute bail order, eventually my earlier bail order also not there, my lord. Now, my lord, my apprehension is that, my lord, now, my lord, after that, my lord, the submission of the charge sheet, the Learned Committal Court, my lord, take cognizance, my lord, and issue summons to me, my lord. Due to, my lord, non-availability of the, my lord, my absolute bail order, my lord, I have the presumption, my lord, I may put behind the bar, my lord, as, my lord, the charge sheet fell under section 364A, my lord, where is the punishment is the, my lord, death penalty, my lord. So, my lord, this bail petition is preferred, my lord. My lord, I will allow my bail petition, my lord, I will appear before the trial court, my lord. Lordship may come to page 20A, my lord, 20 or 20. This is my bail bond order, my lord. This is the only record, my lord, which shows that I earlier, once upon a time, I was released from the jail, my lord. 20A is vernacular, my lord.
This was an order of 29/4 to 29/11/2004.
To the 14, my lord.
14. After that, what happened? So many
My lord,
years.
no order, my lord. Nothing, my lord. No order, my lord. Subsequently, my lord, the court take
Now,
cognizance.
what happened to the trial?
The trial, my lord, presently, my lord, lordship may come to page 26, my lord. Page 26, order dated 16/12/2024, my lord. When, my lord, it was directed, the cognizance has been taken, my lord. Under section 364A.
But why are you not appearing?
My lord, my apprehension that I may be put behind the bar.
Your bail of this order is there already.
My lord.
19/11/2024, 2014 order is there.
Yes, my lord, but that is not the absolute bail order, my lord. That is my problem, my lord. Even my lord, learned court will also ask my counsel, my lord,
Yeah, here no, nothing has been written.
lordship may come to page 36, my lord. I take adjournment, my lord, on that day, my lord. Page 30 is last page, my lord. I took adjournment, my lord. I am ready to appear, my lord, in any condition, my lord. As my lord, I was earlier arrested, my lord, and released by this honorable court, my lord, by the honorable learned court below, my lord. In any condition, my lord. As my lord, under section 480, my lord, there is a bar by the learned magistrate to allow me to go and bowl, as there is a punishment for the death, my lord, death penalty, my lord, is there, my lord.
Yes, Mr. Das.
Yes, Lordship. What I have seen, Lordship, the last order in the scan copy, that the order 29/11/2024/2014, Lordship, it has been stated that he has been given interim and the date has been fixed. Next date is 11/12/2014. But in the scan copy, I have found the last date is only 8/5/14. Whether it has been rejected, accepted, it is not.
Yeah,
Cannot be ascertained from this scan copy, Lordship. However, I also wanted to submit that, Lordship. The two persons, the 164 statement is there. According to him, he has named this person Haroom and Wahid Ali, named in the FIR, Lordship. And they give them some chocolate, pan, Lordship, and he become unconscious. Injection also given. He don't know other person's name. But, Lordship, I have seen some of the persons, Zahiru, he has taken money, 9 lakhs from the father, Lordship. And moreover, the phone that is stated about in this FIR, Lordship, that is of the 3 persons, Lordship. Sadrul, Islam, Akinur, Rahman, and Inus Ali Talukdar. But I apologize, Lordship. In the CD, I have seen, but it is not complete, Lordship. Some of them cannot be read, Lordship.
After 29/11/2014, that order is not there.
Not there, Lordship. Last date is only, Lordship. It is fixed on 29. It is stated that the last date is fixed on, Lordship. 11/12/2014. But the order, what I have found last, Lordship, that is 8/5/2014. Before that, 8/5, and it was 11/12/2014.
11/12/2014. What is the order?
11, there is one order. This is the last, Lordship. This is 29/11/2014. After that, I have not found.
After we said 12.
Oh, no, sorry. I apologize, Lordship. This is the last order I have found. 29/11/2014.
After that, there is no order.
No order.
No, that is good.
Then what happened? But
There is nothing, Lordship.
But there are orders of number 972025 issuing someone.
I have
No,
not
that
found,
is-
Lordship. Here. I have not found. In the scan copy, Lordship. And in the one status is there, Lordship, that is on 28/4/2026. It has been stated that, Lordship, there are 9 witnesses, Lordship, accused persons, out of which 6 are appeared, and 3 persons, including the present petitioner, are yet to appear before the court, and the case is fixed on 22/6/2026 for their appearance.
Well, let him appear. I mean, already interim, one interim was there. Let him appear, go there.
Lordship.
What, Mr.
Yeah, Masan.
Muslim, the learned council. Muslim, the learned council, also have is a PPS are getting for the state. This is an application of the of UNSS. We use this reference example of the state for use of the country connection with South from the previous case conduct. 233/2013 under sections 364 in the category case 2025 FPC, which has been registered as PRC case number 663, stroke review report pending before the learned judicial magistrate class action. The learned council appearing for the accused submits that right order to take provide in order to take 2820 provide in order to take 29/11/2014. The accused applicant was granted interim pre-arrest bail. No, interim pre-arrest bail or what? Not pre-arrest bail.
No, I was arrested.
Interim bail, and he has been, and since then he has been out of the jail.
Yes, my lord.
Since then he has been out of the jail. He submits that though he has been granted absolute bail.
My lord.
Absolute bail. However, the same is not on record. And in view of the aforesaid, the accused applicant is apprehending that he may be arrested if he appears before the judicial minister first class from a hot ceiling.
South Salmana Mankasar.
Yeah?
South Salmana Mankasar.
South Salmana.
South Salmana Mankasar.
South Salmana Mankasar. But this is passed by order passed by whom?
Last order, my lord. Last below part, judicial magistrate first class SSM. South Salmana Mankasar. Page 36.
Okay, South Salmana Mankasar. The learned counsel submits that in view of the section involved in the instant case, if he appears before the concerned appears before the subjudicial appears before judicial magistrate first class. What South
Salmana Mankasar.
he may be arrested. He submits that he is willing to appear before the court and fully cooperate with the trial of the case. Therefore, he should be allowed to go on pre-arrest jail in this case. It's TCR in the instant case has been received. It is seen that next date fixes on
22/6.
22/6/2026. Taking into account the effects of the case, this copy of the court the accused should be granted interim bail so that we can appear before the learned South released on bail of bond of rupees 30,000 subject to the satisfaction of the the satisfaction of the judicial magistrate first class
South Salmana
Mankasar, subject to the condition that the accused applicant should appear before the learned court of judicial magistrate first class South Salmana Mankasar under next date fixed. That is on 26/2026.
22/6/2026.
In the above terms, the instant the application is disclosed. TCR please.
We have received the case diary.
Pass it over for time being.
May I please, Lord? The report was called for, my lord. Without registering the case, my lord, the police, my lord, frequently asked the petitioner regarding monetary transaction.
Report was received or?
Report must call for, my lord. We have been informed by the investigating officer that no such case is pending, my lord.
No case is pending. We'll dismiss it. We'll record his statement.
Lordship,
Heard Mr. R. Ali Dalone.
FIR file GT was made, case did not registered. Lordship.
Heard Mr. R. Ali Dalone counsel to the accused. Also heard Mr. Isaac Durwal for the state. This is an application under section 4 to BMS for contempt of his bill to accuse applicant in apprehension of his arrest in connection with British Police Station GD number 1228/2026. The cognizance of this court by 2011/2026. All for a report from the British Police Station if there is any case filed against the accused applicant, accused applicant. Though no report has been received when the matter was taken up, but how the DPP submits the previous received instructions from the concerned officer in charge of Constitutional Police Station that no case has been filed or registered to make accused applicant till today. In view of the opposite, there is nothing. In view of the opposite, since there is no apprehension of arrest for the accused applicant, the instant review application is dismissed.
Dispose of, madam.
Dismissed. There is nothing. Dismiss them, dispose.
Object.
May it please your lordship, my lord. 41 is your lordship anticipated bail, your lordship. So all the three cases arising out of the same affair, your lordship. So initially, your lordship, for all accused persons, we preferred an anticipated bail. Subsequently, 2 persons have been arrested. That is item number 42 and 43, your lordship. So may I, lordship, draw your attention at item number 41, that is anticipated bail, your lordship. FIR in a nutshell is that, your lordship.
Yes, huh?
41, your lordship.
Yes.
So FIR in a nutshell, your lordship, is that on 6/5/2026, your lordship, in the absence of the husband of the informant, your lordship, page lordship 10 and 11 is the translation, your lordship. So that day on 6/5/2026, your lordship, in absence of the husband of the informant, your lordship, the accused persons named in the FIR, your lordship, they illegally trespass into the premises of the, your lordship, the informant, and thereafter, your lordship, all the accused persons, your lordship, picked up quarrel, and subsequently, your lordship, some of them, your lordship, accused number 3, your lordship, smeared chili powder, and the other accused person, someone, your lordship, allegation is that assaulted with a wooden button, your lordship, and some other, your lordship, allegation against them is the lordship that picked up quarrel, cut hold the tuft of hair of the lady person, your lordship, and pull them out of the house, your lordship. So these are all allegations, and your lordship, that allegation is also, your lordship, restricted to, confined to, your lordship, that because of the assault with button, your lordship, one of the, your lordship, the family members of the informant got head injury, fractured. So I don't know, your lordship, what is there in the case diary, your lordship. So far, the actual fact is otherwise, your lordship. Actual fact is that, your lordship, the whole dispute, your lordship, confined to arising out of a land dispute. There are some pre-existing enmity between the two families, your lordship, the informant and the, your lordship, accused persons. So, your lordship, so long back we have purchased a plot of land, and accordingly registered sale deed was executed in our favor, your lordship. Accordingly, your lordship, on the strength of the FIR, your lordship, this mutation has also been granted, your lordship. But the thing is that what happened is that, your lordship, despite the fact, your lordship, mutation is granted, but possession is not been handed over. So time and again, Your Lordship, we exerted pressure, mounted pressure, Your Lordship, to Your Lordship, to hand over, to deliver the possession, Your Lordship. That has not been done. And on the day of incident, Your Lordship, eventually on the last time, Your Lordship, we approached before the member of the informant, Your Lordship, to deliver the possession, Your Lordship. So that day, Your Lordship, they themselves, Your Lordship,
Is there any sell deed?
sell it, Your Lordship. We have not annexed your sell it.
How do you say that there was an agreement and?
So as per Your Lordship, sell it is not there, you know, we have derived the information, instructed that some land disputes.
I mean, if there is a sale.
Supporting is not there, Your Lordship.
Then,
We don't have.
Mr. Borua, what is there?
My lord, in the case that my lord, the injured witnesses, my lord, their statement recorded, my lord. They have implicated all the accused persons, my lord. Although my lord, there is no specific, my lord, but there is no specific allegation, my lord, that he has beaten with a batam or he has beaten with a, my lord, rod.
So many people were there.
So many people are there, so my lord, but they have all the names that they have implicated. They have taken the name of the injured witness, taken the name of all the accused persons, my lord. And secondly, my lord, one Dildar Hussain, my lord, he sustained injury.
No, sir,
Let me complete. One Dildar Hussain, my lord, he sustained injury, my lord, and as per the medical report, my lord, this injury is simple, my lord, and caused by blood impact, my lord.
So there is the case, Your Lordship. So picked up some quarrel altercations here, they were not denying the fact, Your Lordship. But the injury is simple, Your Lordship. Both sides, Your Lordship.
All these cases, I mean,
Arising out of same FIR, Your Lordship.
two bail applications.
Two application. One is, Your Lordship, that is item number 42, Your Lordship. He has been arrested on 8/5. Already 35 days behind the bar, Your Lordship. 34 days.
34 days.
34 days. And Your Lordship, the item number 43, he has been arrested on 15/5/2026, Your Lordship. 19 days as on date, Your Lordship. No. 15 of rise of offense.
My only submission that recorded, my lord, there's one person, my lord, injured person.
Not serious injury.
His injury is simple, my lord, caused by blood impact, my lord.
Third, Mr. A, beyond the learned counsel, applicants also published as a board of APD for the state. Is an application under section 42 of BNSS 2023. Playing for grant of PRS bail to the accused applicants in connection with Moirabari PS case number 46/2026 under section 190/191 190/310/310/109 BNS to you. An FIR was lodged on 7/5/2026 by one Sahnaz Begum about the informant releasing that the named the named persons in the FIR came to their house by trespassing their premises on 6/5/2026 at 8 AM armed with several armed with hidden buttons, etc. etc. And thereafter attacked the household members of the informant, whereby some of the members of the family members of the informant got injured. On receipt of the FIR, the police registered the Moirabari PS case number 46/2026 under the information sections. Mr. E. Beyond the learned counsel appearing for the accused applicants submits that there is a pre-existing enmity between the informant's family informant's family with the accused applicants, as the accused applicants as one of the accused applicant had bought neo-UGST bought certain land from the informant. However, the land was not handed over to one of the informant, to one of the accused person. And in view of the aforesaid, the accused applicants visited the house of the informant and certain quarrel took place. However, no such injury was caused by any of them on the family members of the informant. He submits that the accused applicants shall cooperate with the investigation, and therefore custodial detention of the accused applicants may not be required at this case. CD in the instant case has been produced and the same is produced. Mr. Rajiv Bhuvat and APP, on the other hand, submits that there are submits that the family members of the accused applicant, family members of the informant got certain, some injuries which, which are of not serious nature. However, he opposes the bail, prayer of bail of the accused applicants at this stage as the investigation is yet to be completed. This court has heard the submissions made by the council of the respective parties, and after taking into account the whole aspects of the matter, is of the considered opinion that the accused applicant should be granted PRS bail at this space. Accordingly, it is directed that in the event of arrest of the accused applicants, they shall be released on furnishing of bail bond of rupees 20,000 each, with a security of 5 nations, subject to the satisfaction of the arresting authority. Arresting authority with the conditions that the accused applicants shall appear before the investigating authority within a period of 10 days of passing of this order. Then number 2, the accused applicants shall cooperate with the investigation and shall make themselves available as and when required by the investigative officer. Number 3, the accused applicant shall not try to tamper with the evidence and hamper the investigation. So, in the above terms, the instant application is disposed of.
40 to 34 days.
42.
Arrested on 8/5.
Application to the level of 480. The facts will be seen. Then we write that Mr. Diwan submits that due to certain quarrel took place between the family and the informant and the accused applicant and others. However, no serious injury was caused during such assault. He submits that the accused applicant is already behind the bars for last 34 days and further custodial detention of the accused applicant may not be required in the instant case. Also, case that in the instant case is being produced, the same is produced. Mr. RJ Bhuvat, APP, on the other hand, submits that there are sufficient materials against the accused applicant and therefore he opposes the will of the accused applicant. This court, taking into account the whole aspects of the matter, hearing the submission made by the council, if any players of the parties is of the considered opinion that the accused applicant should be granted bail at this case. Accordingly, it is directed that the accused applicant shall be released forthwith from bail, from jail on furnishing of the bond of rupees 30,000. 30,000 rupees security of like nature to the satisfaction of the
Chief Judicial Magistrate Morigaon.
Judicial Magistrate Morigaon. Morigaon, subject to the condition that the accused applicant shall cooperate with the investigation and make himself available as anyone called for by the investigating authority. The above term question in the lecture was disposed of. 43.
43, Lordship, 15/5/2026. As on that, Your Lordship, 28 days. 28 days. Deep oblige, much oblige, Lord.
May it please the Lordship, here it is anticipatory bail application, my lord, for offence registered under section 108 of BNS, my lord. Lordship will find the translated copy of affair at page 10. Page 12, my lord. But the allegation is that, my lord, we mentally, my lord, and tortured him. That's why, my lord, he committed suicide.
Mr. Das, what is there?
Lordship, I have seen that before I go to the allegations, Lordship, abatement, I have to go to the scenario behind the scene, Lordship. Scenario behind the scene, Lordship.
Scenario behind the scene, yes.
It is the accused, Nayan, farmer, producer.
So there was a WhatsApp group.
Lordship, before that, there is a self-help group, Lordship, and according to that, Lordship, the person, suicide note, this Bharat Subedi and the deceased person are the only
Suicide note.
suicide note is there. And there is a WhatsApp message also, Lordship, before he died. And according to that, Lordship, Bharat Subedi and this present petitioner are the signatory authorities of this self-help group, Lordship, and they are the directors also. And according to it, Lordship, they have received one Sanjay from Sanjay Batra deposited 86 lakhs so that he get the maize. Maize.
Okay.
Lordship, maize crops. But he has given 33 lakhs has been already been given to the person, but the remaining 55 lakhs were to given, Lordship.
Advance payment was made.
And it has been given.
33 lakhs advance payment was
86
made.
lakhs. 86 lakhs has been deposited.
86 lakhs has been deposited to
Given.
self-help group.
Lordship.
Okay, by a buyer.
Buyer.
Correct.
And he has been, and they have given 33 lakhs
33 lakhs whom?
to the person, Lordship, buyer. They have given the maize. That means out of 86.
And they have given the maize worth 33 lakhs. That's what you're saying.
Lordship, what 33 lakhs has been given.
What 33 lakh maize has been delivered.
Lordship.
Yes, remaining 55 lakhs.
55 lakhs.
What 55 lakhs
given.
was to be paid. Sorry, to be delivered. Yes.
But the thing is that he has given an FIR, lodged an FIR against this person, the buyer, because they have not given
they have not delivered the maize.
Lordship. They have misappropriated. He has stated. But according to the suicide note, he has stated that this person tried to implicate him, that he has taken the money and forced him to return that money. He tried to lodge an FIR also. Police did not register, Lordship, because he has a high-profile person and he has influence upon this person, a police, Lordship, according to him. So, Lordship, this person, the present petitioner, what he does, Lordship, he has the present petitioner harassed by saying in the social media that he has run away from the police by taking the money. And Lordship, he has also stated that he beat the person, this Bharat Chandra. They are collided. Bharat Chandra, then this Chandan Shah, and this present petitioner. They are all collided and give pressure. And out of this pressure, Lordship, they all wanted to implicate this.
What is there in the suicide note?
Suicide note, he has stated the all things that they have forced also. They have forced this signature also. He is not aware because he is also the signatory authority. So he has signed, but he has not know about any of these things. Some of them he has signed and some of them he has not signed. And in the FSL report, Lordship, one FSL report has been said because his signature, is it his signature or not? It is proved that his signature it is suicide note and other handwriting. But the two cases carrying on with the same simultaneously. One is, Lordship, this whether it has been forced or not, that is also going on. This case, this Fayaz Nayan farmer producer case, Lordship. So according to it, Lordship, it is a abatement.
But this person is named in the FIR, right?
Yes. In the suicide note, this person's name is also there. In the suicide note, this person's name is also there. What he does.
What happens in this case, man? Why story is different? Because this is a company, man. This is not a self-help group. They used to buy agricultural produce from farmers. Then they used to sell it to third party. What happened in this case? They purchased maize from farmers. The produce was stopped. And it had to be sold to a third party. It was sold also. Then out of that whole proceeds, 46 lakhs have been misappropriated. Now, the only thing, my complicity or my involvement or my culpability in this offense, whether I was also a party to that or not. Because the FIR is totally silent. FIR says, I was mentally tortured. That's why, my father committed suicide. Because FIR is completely silent on this aspect, whether I was also, whether in the note, suicide note, because FR doesn't say anything about that.
What happened to the other two persons?
Other one, my lord, one, the Chandan Shah, he approached the honorable court and he was given the privilege of pre-arrest bail. Lordship will find that. Annexure C, my lord.
Annexure?
C. Annexure B is my lord, Sessions Court order, and Annexure C is this honorable court's order, my lord. Page 18. He was given the privilege of
He
pre-arrest.
was implicated for that, Lordship. He has been asking for 1.5 lakhs for settling the matter. His allegations are that
Chandan
Lordship,
Shah's
Shah's
allegation. The petitioners in this
petitioner's
bail
allegation that 1.5 lakh has been asked to the deceased so that the matter can be settled. I've given the CD, Lordship.
And the FIR doesn't disclose anything about the suicide note. Only he says, my lord, he left behind a WhatsApp message. Well, that's it.
It is a diary. He is written in the diary, Lordship. It is there.
I mean, these kind of things happens when like somebody commits suicide only because it was put it in the WhatsApp group. Then I mean, how can?
But here, Lordship, the only thing is that they want to implicate him, Lordship. Only he. And they also want to take 1.5 lakhs.
Where is that? He has written that he is committing suicide because of this.
And before he died, Lordship, the message has been given.
But here the
Message is there, Lordship, in the message in the pink color earlier in the WhatsApp group. It is there. You want to die.
Which page he has written? He's only alleging that this has been made, I mean, he wanted to stay or something, but that he has committed suicide because of this way.
It is not accurately lordship, but it is suicide may be allowed to few lines maybe. Because I have.
No, he's writing lot many things, but that this is the incident because of this, which he has committed suicide. Where is that?
May I be allowed? However, moreover, lordship, his.
No, you
wife
tell me
was-
where is that, Mr. Das? You say there is a suicide note. Where is the suicide note? But suicide has to be linked to the note, right?
Lordship.
He has
Lordship,
to,
after a few
he
minutes.
has to mention that I am committing suicide because of the harassment of by these people or because of this. Where is that? He is writing certain things. Yes, he has been I mean harassed or like he is thinking that he has been implicated, but he hasn't stated anywhere that like because of this he is committing suicide.
After 5 minutes, lordship, I will look into it and turn to the portal.
There is nothing there. I've seen this. Okay, we'll take it up after 5 minutes.
My pleasure, Lordship. Lordship, in compliance to the interim order, my lord, dated 18/5/2026, the petitioner appeared before the investigating officer initially on 23/5/2026, my lord. On that day, my lord, the certified copy was retained by the investigating officer. Again, she was called on 25/5/2026, my lord. On that particular day, my lord, her statement has been recorded. So far, my instruction is concerned, my lord. On 2 days, she has appeared. Lordship, this is a case, my lord, where there is no direct connection between the present petitioner and FIR, my lord. Lordship will kindly come to the FIR, my lord. Lordship will find it at page 10, Lordship. Allegation is that, my lord, 64 bags of pan masala and 16 bags of zarda were sent to certain location, my lord. And there were 3 persons in that particular truck, my lord. And subsequently, that truck did not reach the destination. Rather, it found missing. And thereafter, the truck was found at Amingaon area before, in front of the Narayana Hospital, my lord. That is the allegation. And the driver was found missing. Driver and one of the handyman was found missing. Another person was found in an intoxicated state, my lord, in the truck. There is the allegation.
Now, I
My lord,
don't understand. What was the allegation? Who are you?
My lord, I am the elder sister of that Somen Boro, who was the driver of that particular truck.
Somen Boros.
Somen Boro was the driver, my lord. He has already
Is there
been.
an allegation against you
There is no allegation, my lord.
in the affair?
No, my lord. What happened, my lord? A notice under section 179 was served to my husband, my lord, asking me to appear before the investigating officer. Subsequently, on 15/5/2026, my lord.
Yes, ma'am.
Lordship, I have gone through the statement of the Somen Boro, who happens to be the driver of the vehicle that has been found abandoned. Lordship, present petitioner is a sister of the driver. And the driver, who happens to be the main accused, he has implicated her in such a way that from the statement, it is revealed that I'm coming speaking from the right. I Somen Boro, do hereby stated that on the date of occurrence, I was driving the vehicle carrying the consignment. Prior to the occurrence, I had entered into conspiracy with my associates, so and so, so and so. I further stated that on the date of occurrence, after reaching a scheduled place near a gas agency, I made a handyman and laborers accompanying the vehicle consuming intoxicating substances, due to which they become unconscious and incapable of resisting. I further stated that after the theft, I remained in contact with my associates, namely so and so and so and so. Subsequently, the stolen articles were transported and disposed of at different places. Out of the stolen property, a substantial quantity was sold and proceeds were generalized herefrom. I further stated from the sale of the stolen property, I received approximately rupees 4 lakhs. And I remained in telephonic contact with my sister, the present petitioner, regarding the said amount. On the date of occurrence and thereafter, I spoke with Monica Chaudhary, that is my sister, over phone regarding the money. I further stated that during the early hours of the day following the occurrence, Monica Chaudhary came to meet me at North of Gauhati under Kabul district. During the said meeting, I handed over approximately 4 lakhs to Monica Chaudhary and
Money has been recovered.
money has not been recovered. Not yet recovered. He has handed over 4 lakhs to her and asked her to hand it over the same to her, to his wife.
Lordship, we have made a specific statement in para number 6, my lord.
But
Page
in
5.
statement before the IO, she has denied all the states. She has not received any money. She had given.
Later cooperate.
I leave it to her.
Heard Mr. P. Das, the learned counsel appearing for the advice. Also heard Mrs. Bora, the learned appearing for the state. Is an application of section 482 of the NSS, paying for grant of clearance by whose applicant in connection with SL number PS case number 49/2026 registered under sections 123/305 bracket C of BNS 2023. A coordinate bench of this wide order with 18/5/2026 has granted interim clearance bail for the accused applicant with a direction to appear before the investigating officer within 7 days. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, wide order dated 18/5/2026, the accused applicant has already appeared before the investigating officer and brought her statements recorded. The same aspect has also been confirmed by the learned TPP appearing for the state. The case that in the instant case has been produced and the same is produced. Taking it on the fact that the accused applicant is cooperating with the investigation, this court is of the considered opinion that the interim PR is well so granted wide order dated 18/5/2026 will be made absolute. Accordingly, the interim order dated 18/5/2026 is made absolute. Is hereby made absolute, and the instant AB application is disposed of.
Deeply appreciated.
May I please your lordship, my lord? Under 482, my lord, the GNSS, my lord. Last time it was listed, my lord, we were provided protection, my lord, under section 482, my lord, and by the time we have recorded our statement before the animal.
What was the allegation?
Allegation, my lord, this assault and all this thing is the counterblast of our affair, the same incident, my lord. Then this is the affair. Affair is page, my lord, 9, my lord. Which is apparently looks not really believable, my lord. Allegation mainly this group of people came and she stays alone, my lord, and assaulted her or attempt to drag her out. That is the allegation, my lord. And these allegations is the counterblast of the affair, my lord, next affair, my lord, page 13, lecture B, my lord, which is most serious, my lord. We have been assaulted, my lord, and our house has been set on fire, my lord. I have also annexed the photograph also. And our hands and we have been fractured, my lord. 2 people, person has been fractured. Medical certificate also annexed, my lord. I have annexed C, my lord, page 19, my lord. From their assault, my lord. Subject to what my sister will provide. Case diary.
Lordship, I have gone through the statement of the eyewitnesses. There are 2 eyewitnesses along with the statement of the victim. So they have implicated, categorically stated, the complicity of the present petitioners in the NS crime.
Kindly see affair lodged by us, my lord, the allegations. These sections are 333, 326, my lord. Is my lord, that is life imprisonment also there, 1152.
Injury is found there. No injury is found. Injury report says. Otherwise, Lordship, the statement of the eyewitnesses are like this. Statement of witness name is Saddam Hussein. মোৰ নাম কোর্ট কর্মতে সত্য হয় মোক কবলগীয়া যোৱা যে ইংৰাজী 24 তাৰিখে নিশাৰ ভাগত হাইৰুন নেছা ঘৰৰ পৰা চিঞৰ বাখৰ শুনি মই বাহিৰলৈ ওলাই যাওঁ তেতিয়া মই দেখা পাইছো যে বিদ্যুৎসাৰ ৰেহমান সিৰাজুল ইছলাম আৰু ৰাজিম আলিয়ে হাতে হাতে দা লাঠি আৰু ডেগাৰ লৈ ওচৰীয়াৰ ঘৰৰ চৌহদত বলপূৰ্বকভাৱে প্ৰৱেশ কৰিছে তেওঁলোকে খাইৰুল নেছা আৰু তাইৰ তাজিয়া বেগমক মাৰধৰ কৰিছিল মই নিজ চকুৰে মাৰধৰৰ দৃশ্য দেখা পাইছো. The same sort of allegation is given by another eyewitnesses.
Let him cooperate and
Lordship.
third Mr. Chaudhary done it for selected for the accused applicants. Also got and this message for us, along APP for the state, it is an application for the PRSs to be complete. Granting for PRS mail to the accused applicant for the Romania PS case number 97. Under sections 231, bracket 2, stroke 74, stroke 75, 351, bracket 2, stroke 224, bracket 6, stroke 35 of BNS to this. The allegation, the FIR laws, the allegation in the FIR is that the accused applicants, after expressing the case of the house of the informant, house of the informant, house of the informant, assault of the a coordinate bench of this court by its order of 2026 is granted interim PRS bail to the accused applicants in the accused applicants in the instant case with the direction that the accused applicants should accused applicants shall appear before the investigating authority within 7 days. Versus the learned counsel, if the accused applicant submits that in terms of the procedure of the 25/2026, the accused applicants have already appeared before the investigating officer. Investigating officer, investigating officer, and got their statements recorded. Therefore, he submits that the accused applicants shall cooperate with the investigation, and therefore the custodial detention of the accused applicants may not be required in the instant case. Is that in the instant case is being produced and the same is produced? The learned APP, as I said, learned APP confirms that the accused applicants have already appeared and submit and make their statements recorded. Taking into account the aforesaid facts and the submissions made by the council of creditor respective parties, this court will adopt consulate opinion that the interim PRS bail granted on 25/2026 to the accused applicants should be made absolute. Accordingly, the interim PRS bail order dated 25/2026 is hereby made absolute and absolute in the same terms and conditions as stated in the aforesaid order dated 25/2026. In above terms, the instant the application is disposed of.
Made please, Your Lordship. Well, here, your lordship is a PRS bail, my lord. Your lordship will find the FIR, my lord, page 9, my lord. Yusuf Ali. Yusuf Ali.
Oh, Finjan matter. Yusuf Ali and others.
And the 7th line, my lord. The accused number 1 was
Yes, which line?
well, from the 7th line, my lord. Accused number 1, lordship has got it, my lord.
Physically and mentally
Torturing me in various ways as a result of the conspiracy and incitement of the accused number 2, 3, 4, and 5. And the petitioner before your lordship is 2, 3, 4, and 5. My lord, 2, 3 are my lord the parents, my lord. 4 is my lord his sister, and 5 is my lord brother-in-law, my lord. And they were nowhere connected, my lord, in this case. And they reside separately, my lord. It's around 20-25 kilometers away, my lord. And the main accused has already been arrested. Petitioner number 1 is the father. 2 is mother.
Yes, I was born.
Yes, Lordship, I have found, Lordship, that in her statement under 181 statement of the complainant, no such implications
against the
Because they happens to be the parents and sister and brother.
third, Mr. N.J. Dr. the learned counsel, appearing for the accused applicants. Also heard Ms. S.H. Gora, the learned APP for the state, raised an application under section 482 of BNSS to claim for grant of very bill to the accused applicants in connection with the Sigora PS case number 152/2026 under section 61 in bracket 2/69/117 bracket 2 of BNS 2023. An FIR was lodged on 7/5/2026 by the informant, releasing that C being a C has been enticed by the accused number one, namely Minna Hussain, to get into marriage with her. Semicolon, that she had been physically and mentally assaulted by the accused applicant number one in conspiracy with accused conspiracy with accused numbers 2, 3, 4, and 5. Earlier we were looking at accused applicant number one. Accused number 7. No, we'll correct it. That she had been forcefully sexually exploited by the accused number one in the FIR. On receipt of the FIR, police registered Bilasipara police station case number 154/2026 under the aforementioned section. So the inmate counsel, I think the accused applicant submits that the accused applicant number one and 2 are the parents of the accused person number 1 who has already been arrested in the instant case. Accused applicant number 3 and 4 are who are they?
Yes, 3 is sister and
3
4
is the sister.
and
Sister of the accused person number 1 and 4.
brother-in-law.
4 is the brother-in-law of the accused person. Accused person. He submits that the accused applicants reside in a different place about 20 kilometers away from the residential house of the accused applicant, from the accused person number 1, and they are no way linked to the incident that has been narrated in the FIR. The case that in the instant case has been received, and the same is produced. We'll stop taking into account the materials available before. If the materials available in the case diary, and after hearing the submissions made by counsel according to the respective parties, this court is to consider the opinion that the accused applicants should be granted clearance bail at this stage. Accordingly, in the event of arrest of the accused applicants by the arresting authority in connection with Bilasipara PS case number 144/2026, the accused applicants shall be released on bail on furnishing of bail bond of ₹20,000 each with a security of like nature, subject to the satisfaction of the arresting authority, with the condition that with the following conditions: that the accused applicants shall appear before the investigating officer within a period of 10 days for passing of this order. That is number 2, accused applicants shall fully cooperate with the investigation and make themselves available as and when called for by the investigating officer. Number 3, the accused applicants shall not try to influence any witness that may be involved in the instant case. In terms of the aforesaid, the instant AV application is disposed of as allowed.
I'm obliged, madam, deeply obliged. Right, please. The report was
The report was called for that we have received.
Yes, what is that?
No
The
such,
case has been filed.
no such case has been registered.
No, we'll dismiss this. Lord Mr. M. Hussain, the learned. Mr. M. Hussain, the learned counsel appearing for the accused applicant, also for Ms. S.H. Bora, the learned APP for the state. This is an application under Supreme Court equity of BMSS 2023, praying for granting anticipatory bail in apprehension of filing an FIR against the accused applicant, full stop. This court by order dated 9/6/2026, call for a report from the officer in charge of Bilasipara Police Station, police station about filing of any case or FIR against the accused applicant in Bilasipara Police Station. Yeah. A report dated 11/6/2026 has been submitted by the submitted by the SI in bracket UB Uttam Roy, Bilasipara Police Station, which has been handed over by the learned APP to this court. The same is marked X and kept on department. From the perusal of the aforesaid report, it is seen that no case or any FIR or any FIR has been filed against the accused applicant against the accused applicant. In view of the aforesaid, there being no apprehension of any arrest, the instant bail application is dismissed.
Obliged.
Obliged.
That we kept as a part of the record.
We have kept
Obliged.
Item 48. Appeared for the petition, accused applicant when a matter was called for interest of, for the interest of justice, let the matter be listed in the next.
Okay, I want to point out that lordship, the message about the message lordship. There is one thing is there. The deceased person before committing suicide posted a message in the WhatsApp group lordship of the COG SHG group. And in that message lordship, may I read few lines?
You read that relevant portion wherein he is saying that because of his torture or humiliation, he has committed suicide. He is going to commit suicide.
Lordship.
Something like that.
Lordship. Police প্ৰশাসনে মোৰ AFPC বন্ধু বান্ধৱসকলো ৰাজনীতিৰ বশৱৰ্তী হৈ মোৰ বিৰুদ্ধে লাগিছে। এতিয়া মই যি মানসিক চাপ ভুগি আছো আৰু যি মোৰ বেমাৰত আক্ৰান্ত হৈ আছো, বেমাৰ ভাল হোৱা পৰৱৰ্তী বাঢ়ি গৈ আছে। এই জীয়াই থাকিলে হয়তো যি কষ্ট ভুগিব লাগে তাৰে পৰি মোৰ পৰিয়ালৰ পত্নী ল'ৰা ছোৱালী সকলোৱে হাৰাশাস্তি হ'ব, কষ্ট পাব, মানসিক ভাৱে।
So he is indicating that like he is suffering from some disease.
No, Lordship, he is few lines. May I read few or more?
Read.
কষ্ট পাব, মানসিক ভাৱে ভুগি পৰিব, যি অলপ কষ্ট সম্পত্তি মাটি বাঢ়ি আছে, দিনে দিনে মোৰ ওপৰত খৰচ কৰি শেষ কৰিব, তাতকৈ মই মৰিলে 2-4 দিনৰ কষ্ট পাব, লাহে লাহে শান্তি ঘূৰি আহিব, আকৌ নিজৰ কাম বন্ধ কৰাৰ সুযোগ পাব। Then he is stating that lordship for that
He is pointing about his some disease. He's saying that like I'm already suffering from some disease. Then like if I stay more, then I'll be suffering more. My family will also suffer. That is what he's saying there.
A few lines that he also stated.
Leave it.
Lordship.
I don't think it is required.
Lordship.
Mr. M.R. Odhikari.
Why not?
Odhikari, the learned counsel appearing for the accused applicants. The accused applicant also heard Mr. P.K. Das, the learned APP for the state, is an application under section 482 of BNSS 3023. Praying for granting PRS bail to the accused applicant in connection with declaratory PS case number 316/2025, registered under section 108 of BNS 2023. Full stop. An FIR was lodged on 10/12/2025. By one Bhaskar Newar, alleging that in a WhatsApp group wherein his father was also a member, certain humiliating and mentally torturing messages have been posted by the accused applicant as well as some other persons. It was alleged that it was alleged that his father was part of a group, namely Seus Non Farmer Producer Company Limited. It was alleged that because of continuous mental harassment and humiliation, his father under several stress, and on 10/12/2025 at about 5:30 a.m. he committed suicide by hanging. Mr. M.R. Adhikari, the learned counsel appearing for the accused applicant, submits that there is a WhatsApp group wherein the deceased person was also part of it, and the accused applicant is also a part. He submits that the farmers of the village has a self-help group, namely Seus Non Farmer Producer Company Private Limited, wherein the group used to buy crops from various farmers, and after that the same used to be sold to various buyers. He submits that there was a transaction occurred wherein 86 lakhs of rupees, 86.
46 was embezzlement.
No, how much more money was paid initially?
46 was not misappropriated. That is the allegation.
The first time 86 lakhs.
Submits that there was some misappropriation. There was some alleged misappropriation, misappropriation in some transactions, and because of that, there were certain talks and allegations were making round in the WhatsApp group. He further submits that there is no occasion arose wherein anybody in the group had in fact intimidated the deceased or forced the deceased to commit suicide. He submits that the victim person was going under some mental stress because of his long-standing because of his long-suffering disease, and maybe due to that the victim person has committed suicide. In view of the aforesaid, he submits that since the accused applicant is no way connected to any abatement of suicide or he has committed something whereby the deceased person has committed suicide, the accused applicant should be granted the privilege of clearance bail at this stage. Mr. K.K. Das, the learned counsel, learned APP, on the other hand, opposes the bail application, stating that there were materials, and there were various messages written by the victim person before his commission of suicide, and therefore this is not a fit case wherein the accused applicant should be granted clearance bail. The case diary in the instant case has been produced before this court, and the same has been produced. After hearing the submission made by the counsel appearing for the respective parties, this court is of the considered opinion that the accused applicant should be granted clearance bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Dekiazuli PS case number 316/2025 it is 25, no?
2025.
25. He shall be released on bail on furnishing of bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority, subject to the condition that number one, that the accused applicant shall appear before the investigating officer within a period of 10 days. Number two, that the accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. Number 3, accused applicant shall not try to influence any of the witnesses that may be involved in the incident. In view of, in the above terms, the instant review application is disposed of as allowed.
All right.
Serial.
One of the main cases related to appeal against acquittal, but there is an I for condonation of delay first. And
Notice was issued.
yes, notice was issued.
You
No,
are appearing for respond number 2. Are you opposing his thing?
Lordship.
Huh?
Lordship. I have filed our lordship, affidavit lordship.
Where? Where is that?
No, report lordship.
Affidavit of person.
Lordship, they have not explained the delay of the property. They have not explained the delay property.
Delay for how many days?
115 days.
115 days. This is what is the case? As appeal against acquittal.
Appeal against acquittal.
Appeal against acquittal.
Yes. Conviction lordship.
NI case or what?
NI case. Appeal against conviction lordship.
Appeal against conviction is.
Conviction lordship. Nothing can be acquittal. He has been acquitted. Acquittal.
Hmm?
Page number 42 of the criminal appeal.
You are filing an appeal against acquittal.
Appeal against.
Acquittal of him who what?
Yes.
Hmm?
Yes, sir.
Sanwardamal Agarwal.
Yes.
He has been acquitted.
Yes.
Of what offense? NI.
NI offense.
How much money?
Check was of 1 lakh rupees.
1 lakh rupees.
1 lakh.
What was the conviction term?
It was under section 465.
How many months? 6 months.
Yes.
Huh? 6 months or something else?
I think you are 6 months.
You think 6 months. You are not confirmed.
Amount was 1 lakh.
Hmm? Heard Mr. Heard Mr. Yeah?
G. Kaushik.
G. Kaushik, the learned counsel, attending for the applicant. Also heard Mr.
A not
A not for respondent number 2. Respondent number 2. The instant application under section 5 of the Limitation Act 1963 has been filed praying for condonation of delay of 115 days caused in preferring the connected criminal appeal. Full stop. An affidavit in opposition has been filed by the respondent number 2 opposing the instant application for condonation of delay. This court has gone through the explanations given for delay in filing the instant connected criminal appeal, which is available at paragraph . It is not properly explained. You need to explain
Your Honor,
every day.
Your Honor, the
Anyways, we are condoning this explanation given in para 3 of the application full stop. Having found the explanations justified, this court is the instant found justified. The instant IA is disposed of as allowed. Registry to register the connected criminal and list it after 3 weeks.
much obliged.
May I please your lordship?
Yes.
I was constrained to bother your lordship with this review application. Your lordship will remember the order that your lordship has passed is at page 14. Now, my lord, to refresh your lordship memory regarding the case, my lord, a plot of land measuring 2 kathas were, my lord, allotted to the father of the petitioner. Then, my lord, he had paid the premium, but it was not, my lord, his name was not given. Then, my lord, he died and the daughter filed this case, and eventually, my lord, your lordship has allowed the prayer. This was the second case. The line, my lord, sentence by which, my lord, the petitioner is aggrieved, if your lordship comes to page 18.
Page 18, yes.
18, paragraph 9. Maybe, my lord, it will be very clear if your lordship reads paragraph 8 also, my lord. May I read from paragraph 8, my? The aforesaid enquiry report reveals that an enquiry was conducted in presence of the petitioner as well as one Chittagopal Dotto, wherein it is found that under Dag number 1266, 1 katha 5 lessers of land is in possession of the petitioner, and the residents, namely Chittagopal Dotto, Monigopal Dotto, Nirod Kumar Dotto, all sons of Malik Dotto have been illegally occupying certain portion of the land belonging to the petitioner, and the same fact has been informed to the aforesaid residents residing in the eastern side of the boundary of the land of the petitioner. Therefore, it is discernible from the aforesaid enquiry report that the petitioner is in possession of 1 katha 15 lessers of land and such.
1 katha 5 lesser.
I'm sorry, mother. 1 katha 5 lessers of land and certain portion of the 2 kathas of land allotted to the petitioner's father have been occupied by the residents residing in the eastern boundary. That is, my lord, the Dottas. Now, your lordship will kindly come to paragraph 9. In view of the aforesaid, the learned counsel appearing for the parties is in agreement that the instant case can be disposed of with a direction to the respondent authorities to demarcate the allotted land of the petitioner and thereafter do the necessary correction of the land records within a specified time. Accordingly, it is directed to the respondent authorities, particularly respondent number 5, to carry out the exercise of demarcation of the boundaries of the land of the petitioner covered by Dag number 1266 and thereafter correct the land records suitably. Now, this portion, my lord, without disturbing the respective possession of the petitioner and other residents of the eastern side of the boundary of the petitioner's land. Now, my lord, they are occupying my 15 kathas of land, my lord.
But demarcation, I mean, demarcation can be done. It cannot be, I mean, they cannot be dispossessed by this.
My lord, in fact, the allotted plot of land is, my lord,
The
2
allotted
kathas.
land is 2 kathas. Right. Now, dispute is that like some land has been occupied by them. Whether rightly or wrongly, that's a different thing. Now, demarcation, I mean, why demarcation proceeding? They cannot be dispossessed. I mean,
No,
that obviously you will have to go to a civil court for
yes,
that.
my lord, I understand. What I, my lord, submit is that, my lord, that later give the, my lord, 2 kathas of land, it may not be the encroached part.
See, from the 2 kathas land only, you are occupying now 1 katha 5 lesser.
My lord.
And other land is with them.
Not entire, my lord, on the eastern side.
Oh, but some portion of land has been occupied by, that was the allegation.
Yes, my lord.
Now
that is the finding of the inquiry, my lord.
Filing of the inquiry. Now, thing is that like now how it can be done? Because the position cannot be disturbed by this court without, I mean, having any right title or like without having any proper documentation of which.
Now, my lord, admittedly, they are also encroachers. They are encroachers and the petitioner is the, my lord, the allotee of the land. So some device, my lord, so that she gets 2 kathas of land. It may not be.
But by way of this petition, it will be difficult, Mr. Chaudhary. How it can be done?
Because total land in that particular Dag is.
The only thing is that like the demarcation, as per the inquiry report, the demarcation can be done. A marking can be done. But as far as like dispossessing them and doing something else, that cannot be done by this court.
My lord, in fact, because this was the second, my lord, round of litigation, and if your lordship kindly comes to the paragraph number 2 at page 15, last sentence, my lord.
The petitioner, being aggrieved by such eviction notice, approached the court by filing WPC such and such. After considering the aforesaid writ petition, on a consensus arrived at by the learned counsel appearing for the parties, the writ petition was disposed of by providing that the respondent authorities shall not disturb the possession of the petitioner over the land measuring 2 kathas. So at that point of time, my lord, she, in fact, my lord, received a notice for eviction because these doctors are very, my lord, influential persons. So notice was issued to her. Then the court said that, my lord, do not disturb her possession.
We'll issue notice today. We'll let them come and say whatever.
This statement.
Let them come. Heard Mr. M.K. Chaudhary, the learned counsel, appearing for the petitioner. Appearing for the petitioner. Please let the instant review petition has been filed. Seeking a review of the judgment in order to 29/4/2026 as files for in WPC number 2802 stroke 2024. Let please be issued to the respondents. Internally in 3 weeks. States for notice will be taken by way of within 3 days. Within 3 days.
Can we serve to the, my lord, standing counsel revenue because they appeared, my lord?
The learned counsel for the petitioner is allowed to serve notice on respondents by handing over the copies of the instant review petition within 2 days. Within 2 days.
By Monday, my
lord. By Monday, by Monday. Let them be listed after 3 weeks. Let them come if some solution.
Your lordship, my lord, some device, my lord, so that your lordship has given the relief, but at the same time, my lord, there may be a problem. How bless?
Yeah, please, Your Lordship. This is an appeal against conviction, my lord, under section 304, part 2, my lord. In the last occasion, my lord, TCR has been called for. That has been received, my lord. We need some time to go through, my lord.
Service also awaited, I think.
Service awaited.
Service is also awaited.
Service
awaited. As per order dated 22/2/2026 and office note dated 22/5.
Office note dated
22/5.
2026.
Service
as per office note dated 22/5/2026. The service is awaited in the instant in the instant case. Let the matter be listed after 2 weeks. After 2 weeks. Mr. Gora is present and Mr. K. Das is present.
Obliged.
May I please the lordship? Last time LCR was called for, PCR was called for, my lord.
Not present.
PCR is not received as yet. Let them listed after 3 weeks.
Lordship, my name is not reflected in the cause list. Register may be directed to reflect my name. I was appointed as a amicus during the condemnation of delay stage itself.
And your name?
Dr. P. Agarwal.
MSP, Dr. P. Agarwal. The learned amicus appointed in the instant case as putting an appearance. The registry to reflect the name of amicus curiae, correspondent number 2 in the court list.
Wait, please, your lordship. Lordship, this IA is for suspension of sentence. This man has already undergone 4 years and 10 months. 4 years, 10 months, I suppose, my lord, for suspension of sentence. 4 years, 10 months, suspension of sentence, my lord. By and large, my lord, our High Court, my lord, 3.5 years in cases where the punishment is 10 years, 3.5 years, my lord. normally, my lord, suspension of sentence is considered, my lord, and it is 4 years and 10 months.
Lordship, in this matter, Lordship, I am yet to receive the objections, Lordship.
You have to file objection.
I have to file my objections, Lordship.
How much time will it take?
Let it be immediately on the reopening, Lordship.
My lord, reopening would be more than 5 years. My lord.
Now, before reopening, may not be required, may not be possible also. Let them file. Since you are already there, enjoy some more time.
What is the impersonation?
This was learned counsel appealing for the appellant. Is it an appeal or what?
Yes, it's an appeal, but here it will be applicant because it's an.
For the applicant, also heard Mr. Architect Chaudhary, the learned, senior counsel, appearing on behalf, appearing for NCB.
Yes, Lordship.
Appearing for NCB. This is that by MSLDV. Full stop. Mr. Chaudhary believes that he should be given some time to file an objection to the IAC that has been filed by the
No, it will
let the matter be listed.
14th of July, my lord.
Yes, 14th of July.
That is right.
Wait, so lordship, it's an IA paying for leave to file an appeal against the acquittal, lordship. Notice. we have
Notice is served, no?
Notice served, lordship.
Huh?
Notice served.
From where is it?
Actually, there is an office note, lordship. We took the steps. From office note, it is not clear whether it is served or not, but we took the step.
The notice or no, not served.
Lordship,
Only that the notice has been issued, it has been said.
lordship.
It hasn't been served. If it would have been served, then they would have said served.
Lordship, the matter may kindly come up.
Notice on respondent number 2.
2, lordship.
Respondent number 2 is still awaited. Later matter will listed. After 3 weeks.
Lordship. And it may kindly be fixed.
Let the matter be listed after the ensuing vacation.
Obliged.